Also at Mr. P. Sundi, learned counsel for the respondent. This appeal has been filed by the appellant slash plaintiff under section 100 of the Code of Civil Procedure, impugning the judgment judgment dated 25/8/2023, passed in title appeal number 14/2022 by learned civil judge, senior division, Sonitpur, whereby it upheld the judgment and decree dated 14/2/2022, passed in title suit number 22/2013 on 14/2/2022 by the learned Munsif number 1 Tejpur, whereby the no, 14/2/2023. Stop. After hearing the learned counsel for both the sides and after considering the memo of appeal as well as documents annexed therewith, following substantial question of law is formulated in this second appeal within inverted comma, whether the trial court and the first appellate court erred in holding the defendant number and the respondent number 1 as a co-owner of the suit land measuring 4 bigha, 4 kotha, 15 lechas, when the entire amount of the premium for conversion of the suit land from annual patta land to periodic patta land was paid only by the appellant. Stop. This appeal is admitted. Call for the records of title appeal number 14/2022 as well as records of title suit number 22/2013 from the trial court. Who is appearing for respondent number 2?
But I am appearing for all the respondents.
Both the respondents. Since Mr. P. Sundi has appeared for both the respondents, no formal notice need to be issued. You were the plaintiff in the suit.
No. He was the
No,
defendant.
but he was the plaintiff.
You were the
I
defendant.
was all the time defendant.
You are Noor Islam.
I am Noor Islam.
You have wrongly mentioned in your cause title as plaintiff.
Oh, my lord. My lord.
List accordingly. Whether any execution case has been filed.
Yes, my lord, that has been filed. It is, my lord, that is why I got the copy, my lord, day before yesterday, it was served.
Again in execution case.
That is execution case number-
I heard Mr. P. Mohanto learned
05 of 2024.
counsel for the applicant also heard Mr. P. Sundi learned counsel for the opposite party respondent. This application under order 41 rule 5 of the Code of Civil Procedure, 1908 has been filed for staying the execution of the impugned judgment dated 25/8/2023, passed in title appeal number 14/2022 by the Court of Learned Civil Judge, Senior Division, Sonitpur. Stop. I have heard learned counsel for both the sides having considered the submissions made by learned counsel for both the sides, and after going through the application filed by the applicant,
Application 05 of 2020.
the further proceeding of title execution case number,
05 2020.
no, before that. In the connected appeal, already a substantial question of law has been formulated. And before that, again before that, the applicant has impugned the aforesaid judgment by filing a connected regular second appeal, which has been registered as RSA number 159/2024. Stop. In the said appeal, substantial question of law has been formulated and same has been admitted, and notices are issued to the parties. And records are also called for. Stop. In view of above, further proceeding of title execution case number
05 of 2020.
05 of 2020,
Forward.
24,
Pending in the court of the civil just.
pending before the Court of Civil Justice Senior Division Sonitpur,
No, junior division, my friend. Junior division number 1.
Civil Judge Junior
Junior
Division
Division
number
number
1, Sonitpur, shall remain stayed till the pendency of the connected second appeal.
Okay.
This interlocutory application is accordingly disposed of.
Disposal.
Much of.
Bye.
None has appeared for petitioner on call. List the matter. What to do? We'll take it up after some time.
My plea, your lordship. On the other day, lordship, your lordship has already heard this matter.
You have gone through.
Just, if I may, lordship, although I have concluded my argument, just one thing I want to place your lordship, that subsequent notification is there regarding, amendment of rule, lordship, that I am just placing for the lordship.
What is that?
My case is covered that particulars are not there, that part is there, lordship. Rule 3, subclause 4, lordship, may kindly see. It was amended on 23rd December 2022. No notification. Here is subclause 4, lordship, may kindly see. The classification, weighing, packaging, and numbering referred to in this sub-rule shall be done in the presence of such witnesses, and the person from whose possession the drugs and substances was recovered, and a mention to this effect shall invariably be made in the Panchnama drawn on the spot of seizure.
No, it has been mentioned.
No, here it is mentioned that one person was holding, but who was that person? That is not there. So
No,
that is the person who from whose person it was recovered. I will be arraigned under section 29 of the NDPS Act, not under other sections. So they have made it clubbed it together that they have made it projected that both were carrying. Although FIR is clear that one person was having it.
Lordship, I have
That-
seen into the records, Lordship. In the seizure list, it is clearly written, Lordship. From whom it is the present petitioner, Lordship. May I allow to be?
Your name is mentioned in the seizure list.
If it is there, then I have no. That is specifically if it is from my position.
Means-
If there also it is, if it is mentioned from both person, then I have it fixed.
No, it has been mentioned both person.
If it is both person, then Lordship, then who was that
Lordship, it
person
is
who was
written.
holding that is not there.
It is written there.
What is your name?
Wahiduddin.
Oh,
Wahiduজ্জামান alias Suman Ahmed.
then you don't have a case.
Lordship, there I live.
It is there. Lordship.
Then we are dismissing. Heard Mr. A. Ahmed Lalit, counsel for the petitioner. Also heard Mr. A. K. Das Lalit, additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner Wahiduzzaman alias Suman Ahmed, who has been detained behind the bars since 16/1/2024 in connection with special NDPS case number
So Lordship, I'm
Nine.
sorry Lordship for interrupting Lordship. The seizure list which my friend is relying on seizure list Lordship. Seizure list that Lordship, both persons' names are there in seizure list. If I am not wrong, Lordship. If other than that he have relied, I have nothing to say.
No, Lordship, in the last part,
Certified
Lordship, it is
copy of the seizure list which I am having in column number 4, two persons' names are there, from whom says Wahiduddin Kamrul Islam, which I,
MR4,
yes, Lordship, 4.
MR4 of
Four.
20. See last paragraph, next
last
page,
paragraph is there. Lordship.
next page. Can- Special NDPS case number 9/2024. Arising out of Patharkandi PS case number 12/2024. Under section 22C/29 of the NDPS Act, 1985. Pending in the court of Lanitz. Special Judge Karimganj. The gist of accusation in this case is that on 15/1/2023, one Vishal Chetri, SI of police had lodged an FIR before the officer in charge of Patharkandi police station, inter alia, alleging that how much total contraband?
Total contraband, Lordship,
796 crores.
7220 numbers of Yaba tablet.
7,220 numbers of Yaba tablet containing methamphetamine was seized from the possession of two suspects, two accused persons, namely Wahiduzzaman alias Suman within bracket present petitioner and Kamrul Islam. Stop. Charge sheet has been laid.
Charge sheet. I have annexed 3, Lordship, page 15.
Page
15, 1 5.
on receipt of the said FIR. Investigation was initiated and after completion of investigation, charge sheet was laid against two accused persons under section, two accused persons within, including the present petitioner, under section 22 within bracket C/29 of the NDPS Act, 1985. Learned counsel for the petitioner has submitted that in the FIR lodged in this case, the first informant had mentioned that one of the two accused persons who were apprehended, in this case, was holding black color polythene. However, the said person has not been named in the FIR as to who was holding the black color polythene containing the Yaba tablets stuff. He has submitted that there is also nothing in the record to show that there was abatement or any conspiracy by the other accused persons. Learned counsel for the petitioner has referred to Rule 4 of the Narcotic Drugs and Psychotropic Substance within bracket seizure, storage, sampling and disposal bracket close rules 2022, whereby the person from whose possession drugs and substances was recovered shall have to be invariably mentioned in the Panchnama drawn at the spot of the seizure stop. He submits that as same was not done, the petitioner is entitled to get benefit and he is also entitled to get bail on that count. On the other hand, learned additional public prosecutor has referred to the seizure list and has submitted that name of the present petitioner has been categorically mentioned in the seizure list as the person from whose possession, who was holding the black color polythene from where the contraband was seized. Stop. I have considered the submissions made by learned counsel for both the sides and have gone through the materials on record. As on perusal of seizure list dated seizure list within bracket MR number 4/2024, it appears that the seizing officer has categorically mentioned the name of present petitioner who was as the person who was holding the black color polythene from where the seized contraband was recovered. Stop. As in the instant case, the quantity of contraband seized is of commercial quantity. Hence, the embargo of section 37 of the NDPS Act is applicable. And as there are clear incriminating material on record against the present petitioner, this court is of considered opinion that embargo of section 37 of the NDPS Act, 1985 is applicable in this case, and the petitioner is not entitled to get bail due to the said embargo at this stage. Hence, the prayer for bail of the above named petitioner is rejected.
Apply.
Probably 90 days together. I have not received any instruction, Lordship.
Cash sheet laid or not?
No, I have not. Kindly give me some time, Lordship. Few minutes, Lordship. 10
CD was there or
CD was taken back, Lordship.
you find out,
Lordship.
and when will you inform?
Just give me some time, Lordship.
Okay, let him find
Time
out.
being, Lordship. Lordship.
May it please your lordship. Lordship, the matter relates to Bajari Seva PS case number 126 registered under 22C 2529.
Charge sheet has been laid.
So charge sheet has been already filed, it's been submitted, lordship, by the police. It was submitted last year, lordship, or
When were you arrested?
I was arrested on 14/6/2023, lordship. Sir,
What is your ground?
lordship, I have got ailing parents in my hand, in my home, lordship. Apart from that, lordship, I'm just a driver. I'm not involved in this, lordship, because the entire business of transportation, lordship, is handled by my owner, lordship. He was not even questioned in this. Apart from that, lordship, the another vehicle was seized along with my vehicle. The owner of that vehicle has been granted bail by this honorable court, lordship. Already granted bail because of the perfunctory investigation by the police, lordship.
Heard Mr. D.J. Kapil, learned counsel for the petitioner, also heard Mr. K.K. Das, learned additional public prosecutor. Perusal of the scanned copy of the case record of special NDPS case number 70/2023 would be necessary for consideration of the instant bail application, hence call for the same. Registry to issue requisition for the scan. For calling for the scan copy. Let this matter be listed on 29th October 2020.
Thank you.
Orders, item 12.
Mr. Hussain has some difficulty. He had mentioned in the morning.
Sorry, my lord, I am for the appellant. sir.
This is ready for hearing.
Yes, my lord.
Okay.
It is for the,
Heard Mr.
yes, sir. Babu.
S.R. Borgmeier, learned counsel for the appellant, also heard Mr. B. Hussain, learned counsel for the respondent. This case is ready for hearing. Hence, the registry is directed to list this case for hearing in its usual course.
Okay.
Item 13.
I think. That with your lordship service completed, my lord.
Huh?
Service is completed, madam. Maybe 6 for early hearing, madam.
Service is complete. Heard Miss
L. Wajidam.
El Wazida, learned counsel for the appellant, also heard Mr. What is your name?
Sir, yes, Islam.
S. Islam, appearing for
Behalf of K. M. Muzumdar.
all respondents for whom you are appealing. You have to know for whom you are appealing. Learned counsel for the respondent. The service on the respondent is complete and this case is ready for hearing. The records would be necessary. Alright. It appears from order sheets that though the notices were issued to the respondents and service is complete. However, no substantial question of law has been formulated in this case. Let this case be listed for hearing under Order 41, Rule 11 of the Code of Civil Procedure after reopening of the after
Date.
you want a date.
First week of November, maybe.
Let this case be listed for listed again on 5th of November 2020.
Oblige, your lordship.
Maybe the lordship. Allowed, LCR received by the honorable court, maybe fixed for hearing.
Service is complete.
Allowed, as per the order dated 7/8/2023, steps to be taken on upon the respondent number 2 and 3. We have taken steps on 29/8/2023. We got OP number 2 and 3, but they did not appear. There was insurance and OP number 4 is appearing.
But service has to complete on the other
We
response.
sent several notice, lordship. That's the only single point is, in this case only, we unable to adduce on evidence before this honorable court. For that reason, the MSCT case was dismissed.
Who are respondent number 3 and 2 and 3?
Your lordship, owner and driver, your lordship.
That is necessary. This is a case of dismissal.
If they have no objection, so that's only single order is required, remand back for.
Heard. Mr. What is your name?
Island and Devnath.
And Devnath, learned counsel for the appellant. Also heard Mr. H. Gura Gohai appearing for
Respondent number 1, your lordship.
respondent number 1 and Mr. B. Chakravarti appearing for respondent number 4.
Four.
4. On perusal of the office note dated 26/9/2024, it appears that in respect of notices issued to respondent number 2 and 3, neither AD card nor unserved notice have returned back. When have you taken steps?
Pilot,
You submit the postal track consignment report. You take fresh steps. And next time you submit that track consignment report so that we can resume service.
highly obliged.
And the appellant is directed to take fresh steps for issuance of notice on respondent number 2 and 3 by registered post with AD within 7 days from the date of this order, returnable on 6th of November 2024. List thereafter.
Highly obliged.
Item 15.
Please, your lordship. Lordship, in this matter, memorandum of appearance was filed by the respondent counsel, Mr. K. Gogoi, for respondent number 2, my lord. My lord, therefore, the service is complete and LCR is received. Lordship, matter may be fixed for hearing.
Heard Miss M. Kolita, learned counsel for the appellant. Also heard Mr.
B. Sharma.
B. Sharma appearing for
Respondent number 1, NF Railway.
respondent number 1
NF Railway. GM NF Railway.
on perusal of office note dated 21/8/2024. It appears that a memorandum of appearance on behalf of respondent number 2 has already been filed in this case. However, none has appeared.
She is appearing on behalf of Mr. K. Gogoi.
For respondent number 2.
Stop. However, Miss, what is the Miss N. Sharma appears for respondent number 2. This case is ready for hearing. Let this case be listed for hearing
In the usual course, my lord.
in the usual course.
Oblige, your lordship.
Item 16.
May it be pleasure, your lordship. Lordship, as per the last order dated 19/2/2024, we praise for 2 weeks times to take press steps on behalf of respondent number 2, and we have taken press steps on 7/3/2024.
It has, who is appearing for respondent number 2? Anybody appearing for this?
Respondent number 1, I am appearing, my lord, NF Railway. And probably I will appear for respondent number 2 also, but that confirmation hasn't come. So let it be posted after the vacation. By that time, maybe I'll receive the confirmation.
We'll fix it for hearing
Let the service be
because service is complete.
with regard to respondent number 2 also.
2 also.
In the usual course.
Heard Miss M. Kalita, learned counsel for the appellant, also heard Mr. B. Sharma, learned counsel for respondent number 1. On perusal of the office note dated 21/8/2024, it appears that the AD card issued to respondent number in respect of notices issued to respondent number 2 has returned back with the endorsement of receipt by respondent number 2. The notice issued to respondent number 2 is therefore held to be duly served. The records have arrived,
LCR have probably arrived.
I say.
Yes, lordship.
The trial court records have arrived. This case is ready for hearing. List this matter for hearing in its usual course.
Not sure.
My lord, I will refer against my lord, my friend, my lord. Because I didn't, item number 41, my lord, I'll make a mention, my lord. I could not found in my lord in the morning, my lord. My lord, I'm just, my lord, mentioning.
Item number
51, my lord. It's a hearing matter, my lord.
Lordship, I am not in this case.
Oh, my lord, then, my lord, sir. Then.
Obliged.
All right.
Item 19.
Matter, your lordship. This is ready for hearing, lordship. LCR received, lordship.
who is for the other side?
Other side is APR last appellant, the APR and their name is shown in first list, lordship.
Heard Mr. P. Sharma,
Lordship.
learned counsel for the appellant. None has appeared for respondent number 1 and 2. The
48.
trial court records have been received. Let this matter be listed for hearing in its usual course.
Obliged, lordship.
Item 20.
May it please your lordship, as per office note dated 7/8/2023, service is complete upon all the respondents.
This appeal is admitted.
No, your lordship.
Okay. Heard Mr. S. Datta, learned counsel for the appellant. On perusal of the office note dated 7/8/2023, it appears that the notices issued to all the respondents are duly served. Stop. Let this case be listed for admission hearing after Puja vacation on a date to be fixed by registry.
Much obliged.
Item 21.
Lordship, LCR has been received and service is completed, lordship. Now,
Heard Miss
feel of course.
V. Locker, learned counsel for the appellant. None has appeared for respondents. The trial court records have been received. Let this matter be listed for hearing in its usual course.
It's production of additional evidence.
Let this matter. Let the other side appear. We will hear this order 41 rule 27 application. You have furnished a notice of copy of this to other side of order 41 rule 27 application also. This application under order 41 rule 27 of the Code of Civil Procedure, 1908 has been filed by the appellant. No, it is admitted or not, appeal is admitted.
Appeal is admitted.
No, it is not admitted. Let the appeal get admitted. Then we will discuss, then decide the. Before, in the main appeal, let this case be listed for admission hearing after Puja vacation on a date to be fixed by registry.
May it please your lordship. Your lordship, in this case, respondent number 1, 2 and 3 has already entered appearance, your lordship. They are the claimants, your lordship, but as regards respondent number 4, your lordship, service is not completed, your lordship. We had taken steps through Dusty service also, but that report has also returned unserved, your lordship, as he has already shifted to some other place. So, your lordship, my prayer is that name of respondent number 4 may be struck off, your lordship.
Who is respondent number 4?
Respondent number 4 is the owner, your lordship.
Owner is important.
Lordship, but in this case, we had challenged the quantum of compensation, your lordship. Basically, the appeal is on quantum.
Okay. Heard Miss P. Borthakur, learned counsel for the appellant. Stop. None has appeared for respondent number 1, 2, and 3. Learned counsel for the appellant has submitted that the notice on respondent number 2, 4 would not be served even through Dusty mode, as the respondent number 4 has changed his address. She also submits that this appeal has been preferred by the insurance company, mainly challenging the quantum of the compensation awarded, and therefore this appeal may be decided even in the absence of respondent number 4. And she prays for striking out the name of respondent number 4 from this appeal. On prayer of the prayer of the appellant is allowed. The registry shall strike out the name of respondent number 4 from the cause title of this appeal. Let this appeal be listed for.
LCR has been received, your lordship.
The records of the trial court has been received. It will go for hearing.
Lordship.
Let this case be listed for hearing in its usual course.
Okay, is it?
Item 23.
I'm appearing for the respondent also.
Sole respondent,
Yes, Lordship.
none has appeared for the appellant. Miss
Are they?
R. Devi appears
Yes,
for
yes.
the sole respondent. On perusal of the office note, it appears that the records of OA, records of the trial court have been received. Hence, this case is ready for hearing. Let this case be listed for hearing in its usual course.
My place. I ask for condemnation of delay. There is a delay of 140 days, Lordship.
140 days.
Lordship. I have explained in my.
No, but whether notices are served,
Yes, Lordship. Kindly peruse office note dated 15/6/23.
or Mr. R. Ali, learned counsel for the applicant. On perusal of the office note dated 15/6/2023, it appears that the notices issued to respondent number 7-1 and 7-2 have been duly served. Stop. It also appears that the engaged counsel for respondent number 1, 2, 3, 4, 5, and 6 have filed wakalatnama. However, none has appeared. What is to be done?
Kindly IMAB disposal of property. There
Or-
is sufficient.
No. We are fixing whether their names have been shown,
The Okalatnama.
but it is not shown in the cause list. Let the names of the engaged counsel be reflected in the call. Stop. It appears on perusal of the cause list that names of engaged counsel for respondent number 1, 2, 3, 4, 5, and 6 have not been reflected in the cause list. Let this matter be listed again. B. Haldar. This is item number.
Yes, Lordship.
B. Haldar's name is there.
Against IA.
Or against I. Okay.
And-
Line to Katili. Though it appears that though name of one counsel has been shown in the cause list as engaged counsel for respondent number 1 to 6, however, none has appeared for the respondents. Hence, this application is decided ex parte. Learned counsel for the stop. This application under section 5 of the Limitation Act, 1963, has been filed by the applicant/appellant, praying for condoning the delay of 140 days in preferring the connected first appeal against orders, whereby the appellant is impugning the judgment and order dated 31/5/2022 passed by the Court of Learned Civil Judge Bongaigaon in Misje case number 24/2021 arising out of title suit number 17/2021. Where have you explained the delay?
From paragraph 3, Lordship.
What is the cause? Reason?
Basically, the petitioner appellant is about 70 years of age. He was suffering from various age-related ailments prior to passing impugned judgment. If you honor, kindly peruse page number 8.
Yes, thereafter, you tell me the,
And he was under medical treatment, Lordship. If your Lordship kindly peruse page number 11.
okay.
Till
Uh.
30/10/2022. And then here there is a note of 8 weeks rest. Then immediately after recovery, this appeal is preferred. Until then, 140 days. 2 days there. If you wanna kindly peruse page number 11.
Learned counsel for the applicant has submitted that the appellant is aged about aged about 70 years and is suffering from old age ailment and was undergoing treatment for his various ailments. Stop. It is also submitted that when the applicant was undergoing treatment, the impugned order was passed and he could not take steps for preferring the appeal within the period of limitation due to his ailment. Stop. I have considered the submissions made by learned counsel for the applicant and have also considered the other cause shown mentioned in paragraph number 3, 4 and 5 of the application for condoning the delay, wherein he has explained the delay in preferring the connected appeal. Stop. After considering the submissions as well as the ground shown for the delay cause in preferring the connected appeal, this court is of opinion that the delay of 140 days in preferring the connected appeal has been sufficiently explained. Stop. The delay of 140 days in preferring the connected appeal, is, therefore, is, therefore, is hereby condoned. And this interlocutory application is allowed. The registry to register the connected FAO and list the same for admission after puja vacation on a date to be fixed by registry.
I will serve copy of memo to Mr. D. Halder as shown in the.
After registration of the appeal. This interlocutory application is accordingly disposed of.
Item 25.
Yes.
Service of summon was completed on 3/6/2024 upon the sole respondent opposite party. And this application is for condonation of delay under section 5 of the Limitation Act for 141 days in filing in preparing CRP.
Heard, Mr. What is your name?
H. Bhuya.
H. Bhuya, learned counsel for the applicant. On perusal of the office note dated 3/6/2024, it appears that the Lawajima Court by its order dated 31/5/2024 has observed that the notices issued to all the respondents are on the sole respondent.
Sole respondent.
On the sole respondent has been duly served. Stop. Hence, the it is hereby held that the notices issued to the sole respondent has been duly served. this application under Section 5 of the Limitation Act has been filed by the applicant for condoning the delay of 141 days in filing the connected civil division petition, whereby the, which order you are impugning,
22/11/2022.
whereby the applicant has impugned the order dated 22/11/2022, passed in Ms. J case number 21/2021 by the Court of London, Munsif number 1, Morigaon. In connection with title suit number
Title suit number TS 53/21 old and 27/18 old. The new is 53/21.
in connection with title suit number 53/21. Stop. Learned counsel, why the delay has been caused?
Delay. The first cause is the non-communication with the engaged advocate with the petition applicant. On 29/4/23, he was informed and applied for certified copy, and the certified copy was handed
You
over.
have left the, come to page number 4, para 1.
Petitioner.
Second line.
Not intentional and financial problems
page
and
number
non-communication with the advocate.
Page number 4. Page number 4 of your para 1. You have left something blank.
Here is in our office note, is literally written 140 days.
Stop, I have heard the submissions made by learned counsel for the applicant and have gone through the grounds stated in the application for condoning the condonation of delay. Stop. Considering the grounds stated in paragraph number 3 of the said application, this court is of considered opinion that delay in preferring the connected civil division has been sufficiently explained. Stop. The delay of 141 days in preferring the connected civil division, comma, is therefore, comma, hereby condoned, and this interlocutory application is allowed. The registry to register the connected revision petition and fix it for admission hearing on a date to be fixed by it after puja vacation.
Problems.
Item 27.
Lordship, by office note dated 23/9/24, Lordship, we have submitted an affidavit for the paper publication as directed by the order dated 19/8/24.
which is the date when in the notice, date of appearance of the opposite party mentioned in the notice?
Notice of which respondent?
No, in the notice which is published in the newspaper,
Lordship.
you have mentioned a date for a
16th
16th of,
September.
okay. Heard Miss
P. Agarwala.
T.
P.
P.
Agarwala.
Agarwala, learned counsel for the petitioner. None has appeared for respondent number. This is a condonation.
Yes, Lordship, the IA is for condemnation, but service was not completed for respondent numbers 4, 5, 6, and 7. As such, paper publication was directed. We have taken the paper publication and an affidavit has been submitted to that effect. Therefore, Lordship, service is complete, maybe indicated.
None has appeared for respondent number 1 and 3. Stop. Learned counsel for the applicant has submitted that in pursuant to directions of this court, the applicant has furnished an affidavit regarding publication of notice to notice upon respondent number 4, 5 within bracket small a, comma within bracket small b, comma within bracket small d, C and within bracket small d, comma 6 and 7. Let me see. You have not flagged it.
Lordship, the notices are on page number 15 and
Page number,
15, 1, 5.
there is no page. Okay.
And page number
16
9.
September, okay. In view of due publication of notices in the newspaper as per the direction of this court by order dated 19/8/2024, comma, the notices on the aforesaid respondents are held to be duly served. Stop. Any submission?
Maybe fixed for condemnation hearing.
Okay. Let this IA be fixed again. For hearing on the application of on condonation of delay after puja vacation on a date to be fixed by registry. The matter may be listed in the orders column.
May I please your answer? Well, it's in this case, the appeal was, originally the appeal was dismissed.
Appeal was with
Appeal was
second
dismissed
for default.
for default. And that dismissal order was set aside by this honorable court in IA 1643 of 23. Now the case appeal has been restored to file. But during the dismissal of the appeal, the appellant number, the respondent number 1 died.
Respondent number 1.
Ah,
Arvaseni
died.
Iyer. Respondent number 1 died.
Died. And therefore we have filed a petition. After
When he died,
he died, respondent number died on 25/11/2021.
yes.
Therefore, we have filed a petition for condonation of delay for setting aside abatement and the substitution.
That was allowed.
No, that was.
That is under consideration. So this is for setting aside
3370, 3370 is the for condonation of delay of
For-
424 days.
in setting aside
In
abatement.
setting aside the abatement, we have filed another application.
So abatement has to be set aside first.
First, limitation has to be condoned.
Oh, yes. In filing application for setting aside abatement.
We have filed 3 petitions, one for condonation of delay, one for setting aside abatement of substitution, and substitution of the respondent.
Any
number 1.
objection?
No objection, Your Lordship.
Heard Mr. A.C. Sharma, learned senior counsel assisted by Mr.
And Ramalaj.
N.
Rama.
N. Brahma. This application under section 5 of the Limitation Act, 1964 has been filed by the applicant / appellant for setting aside for condoning the delay of 424 days in preferring an application for setting aside abatement of the appeal against respondent number 1. Learned senior counsel for the petitioner has submitted that respondent number 1 had died on 25/11/2021. Why delay has
Originally the case was conducted by Mr. B.R. Day. He died. And the record could not be traced out. When the respondent started executing to know the dismissal of the appeal, thereafter made an inquiry
okay?
and found
Learned senior counsel for the applicant has submitted that originally the second appeal was conducted by
by Mr.
Mr.
B.R.
B.R. Day, who passed away during the pendency of the appeal, and records of the appeal could not be traced out by the newly engaged counsel, which caused newly engaged counsel stop. It is also submitted that when the execution case was initiated by the respondents, the applicant came to know about the death of the respondent number 1.
Date of the appellant.
Date of
Advocate for the appellant.
Date of the advocate for the appellant. Stop. I have considered the submissions made by learned senior counsel. I have also gone through the application for condonation of delay, wherein in paragraph number 2 of the said application, the reasons for delay in preferring the application for setting aside abatement has been explained. After considering the submissions as well as the reasons cited, this court is of opinion that the delay has been sufficiently explained. Stop. For the aforesaid reasons, the delay of 424 days in preferring the application for setting aside abatement on the death of respondent number 1 is hereby condoned, and this interlocutory application is allowed. The
Now you're
next application,
3371.
heard Mr. 3371, heard Mr. A.C. Sharma, learned counsel for the learned senior counsel for the applicant, assisted by Mr. J. M. N. Brahma, learned counsel for the applicant. This application under Order 22, Rule 9 of the Code of Civil Procedure, 1908, has been filed by the applicant / appellant for setting aside the abatement of appeal on death of respondent number 1, Shri Amar Chandra Pincha. Whether notice will go or we can settle.
My lord,
Notice will go to legal heirs or,
no, they have no objection.
Will appear in.
okay. The delay of,
The delay has already been
yes,
condoned.
the delay of 441 days in preferring.
424 days.
424 days in preferring the instant application has already been condoned by order dated 30/9/2024, passed in IA 3370/2024. Mr. H. Bura Gohai, who appears for the legal representatives, who appears for the respondents, sole respondent.
No, he is the main respondent.
Who
The
appears
other respondent.
for the respondents does not have any objection.
No, he is the sole respondent.
Respondent number 1 is the sole respondent, others are pro forma respondent.
Others are.
Stop. Considering the submissions made by learned senior counsel for the applicant, as well as the reasons cited in paragraph number 4, 3 and 4 of the of the application, this court is of considered opinion that the applicant was prevented by sufficient cause mentioned in the application from continuing the appeal against the respondent number 1. The respondent number 1, stop. For the reasons mentioned herein above, this court is hereby set aside the abatement of appeal against respondent number 1 on his death. This interlocutory application is accordingly disposed of. 3372. This interlocutory application has been referred by the applicant / appellant under Order 22 Rule 4 of the Code of Civil Procedure for substituting the legal representative of respondent number 1 on his death. Stop. Learned counsel for the applicant has submitted that the respondent number 1 had passed away on 25/11/2021, and though due to lapse of time, the appeal abated against the said respondent by order dated 30/9/2024, passed in IA number 3371/2023. The said abatement has been set aside by this court. Learned counsel for the applicant has also submitted that who are the legal heirs?
I have mentioned in paragraph number 1.
That Srimati Mangi Devi Pincha, Srimati Indu Devi Sancheti, and Srimati Monica Jain are the legal representatives of respondent number 1 who are required to be substituted in place of the respondent number 1 on his death. Learned counsel for the respondent does not have any objection to the same. The prayer is allowed. The registry to substitute the names of the aforesaid respondents, aforesaid legal representatives as respondent number 1 within bracket small Roman 1, 1 within bracket small Roman 2, and 1 within bracket small Roman 3 in the cause title of the memo of appeal of RSA number 273/2024. This interlocutory application is accordingly disposed of.
My learned friend has already appeared for 1.3. No notice is required.
You are appearing, but this correction has to be made
Correction has to be made.
only after that orders may be passed in appeal.
A mention may be made
Okay.
that the substitute advocate for the substitute has already appeared.
In appeal, the registry is directed to substitute the legal representatives of respondent number 1 in pursuant to the order dated 30/9/2024, passed in IA number 3372/2023, and thereafter list this matter again after puja vacation on a date to be fixed by registry, as Mr. H. Bura Gohai has already appeared for the substituted respondents.
Public.
Item 24.
Written instruction.
What is this?
No, charge sheet has been submitted.
Heard Mr. S. Munir. What is your name?
Yes, Munir name.
Heard Mr. S. Munir, learned counsel for the petitioner. Charge sheet has been submitted.
Lordship. I have given the written lordship, written information. It was there.
Then you have to go to the trial court. This is a 376 case. heard Mr. S. Munir, learned counsel for the applicant petitioner. Also heard Mr. K. K. Das, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid and charge sheet has been laid on 29/9/2024. In view of the laying of the charge sheet in this case, this bail application is disposed of with an observation that the petitioner may approach the trial court and may pray for regular bail before the trial court, if so advised. This bail application is accordingly disposed of.
Yeah, please, your lordship. Lordship, the respondents have already appeared. The matter is already admitted, your lordship, on, by order dated 21/8/24. And, the
Records,
respondents have already appeared here.
whether case records would be required. NCRIC.
The LCR has been.
Heard Mr. A. Bishwas, learned counsel for the appellant. Also heard Mr.
Mr. N.
A. Nayak,
Yes,
appearing for all the respondents.
already responded.
All the
Lordship,
respondents.
we are appearing for the first time, so I kindly request honorable court to give some time for this, preparing for this case.
No, will fix it for hearing.
So last time we have filed a वकालतनामा.
Okay. Appearing for the respondents. On perusal of the office note, it appears that the trial court records have also been received. Stop. This case is ready for hearing. Let this case be listed for hearing in its usual course.
Because, it is dealing with the pension matter, your lordship, maybe because both of us are the legal heirs of a person who died.
This is
There
an
is a
appeal.
dispute with regard to the pension. And, the succession certificate was sought for, so an early hearing may be fixed, your lordship.
But for appeal, if you want an early hearing, then
After the vacation, your lordship.
no, then a application is required. Not on oral mention. You file an application,
We'll
we will-
file an appropriate application.
we will fix
And
it.
the interim that was granted, your lordship, may be extended. Last,
the interim order shall continue till next day.
Hello, list.
obliged.
Yes,
Please, your lordship. Lordship, according to office note, the respondent number 22-125 notice is not served, so we may be allowed to take steps again.
heard Mr. S. Afridi, learned counsel for the appellant. Also heard Mr.
A Bhuya, Lordship, I'm appearing for respondent number 1, 9, 10, 11, 12, 13, and 14.
appearing for appearing for respondent number 1, 9, 10, 11, 12, 13, and 14.
I have filed the wakalatnama for on behalf of the respondent number 228, 15 to 18, and 20 and 22, 21.
Also heard Mr. Miss
A Sharma.
A. Sharma appearing.
Name has not shown, Lordship.
Okay, appearing for respondent number
228,
2 to 8,
15 to 18,
15 to 18,
20 and 21.
20 and 21. Stop.
Lordship, if I may. Lordship, I have not been served with a copy of the memo of appeal and the annexures. Lordship, I pray that one copy may be provided.
Okay. On perusal of the office note dated 23/9/2024, it appears that notice issued to respondent number 22 within brackets Roman 1 to 22 within bracket Roman 5 have returned with endorsement that the addressee is not residing in the given address. Stop. In view of the same, learned counsel for the appellant has prayed for some more time to find out proper address of the said respondents and take fresh steps on this same. Stop. The prayer is allowed. You furnish the memo of appeal.
Yes, sir. I will-
The appellant is directed to furnish a memo of appeal and connected and the annexures therewith to Mr.
A Bhuyan.
A. Bhuyan. Stop. The registry is directed to reflect the name of Miss A. Sharma as engaged counsel for respondent number 2 to 8 and
15 to 18, 20 and 21.
20 and 21. List this matter after puja vacation.
Obliged.
May I please your lordship? Kindly see office note dated 26/9, my lord. Service is complete.
Third Miss, what is your name?
K. Burma.
Third Miss A. Burman, learned counsel for the appellant on perusal of the office note dated 26/9/2024. It appears that the notices issued to respondent number 1 to 3 have been duly served. Stop. It also appears that the records which were requisitioned have already been received from the Court of Learned Additional District Judge Borpeta. Stop. This case is therefore ready for hearing. Let this matter be listed for hearing in its usual course. I'm taking a short break of 1.
May I please, your lordship? As per office note dated 12/9/24, the service upon the sole respondent is complete. LCR have also been received.
Heard Mr. S. Sharma.
For and Thakuria for S, sir.
Heard Mr. N. Thakuria appearing for Mr. S. Sharma, learned counsel for the appellants. As per office note dated 26/9/2024, it appears that the notice issued to sole respondent has been duly served. Stop. The trial court record has also been received. This case is therefore ready for hearing. This matter for hearing in its regular course.
Ma'am, Lordship, in this case, the respondent has filed an affidavit. Against it, I will pray for some time, Lordship, for filing an affidavit in reply.
Heard Miss M. Dev, learned counsel for the petitioner. Stop. None has appeared for the respondent. Learned counsel for the petitioner submits that she needs some time to file an affidavit in reply against the written objection filed by the respondent in this case. The prayer is allowed. Let this case be listed after puja vacation on a date to be fixed by registry. The interim order shall continue till next day.
Alright.
May I please, lordship, as per office letter dated 28/2024, lordship. LCR has been received and AD card also received, lordship.
Heard Miss,
P. Odhikari.
heard, what is your name?
P. Odhikari.
Heard Miss P. Adhikari, learned counsel for the applicant. You are appearing.
Yes, ma'am.
Also heard Miss A. Gayan, learned standing, learned
Yes.
central government council, appearing for the sole respondent. The trial court records have also been received. Let this case be listed for hearing in its usual course.
Item 46.
Yes. None appears for the appellant on call. Miss
S to the lordship.
S to D, appearing for respondent number,
Sole respondent.
appearing for sole respondent is present. The trial court records have already been received. The appeal is admitted. We can fix it for hearing.
Lordship.
Let this matter be listed for hearing in its usual course.
Obliged lordship.
Item 47.
Yes, what is this?
Lots of decision application for title suit arbitration 3 of 99.
You trade time for
Yes, ma'am.
filing.
I don't take any objection when court may refer the case to the dispose of the matter, my lord.
Because thereafter the arbitrator has to be appointed. Lots
Yes,
of-
ma'am.
This is the dismiss for default. It was done on
Yes,
25/3/2004.
He has approached against the dismiss for default, my lord.
Why this first appeal against order has been?
It's a lottery at case number 9. Lordship.
This case was dismissed for default.
Default sir, because in the courtroom as well as in the court record room, the record was not traceable.
Thereafter, you filed an application for
There are two applications.
Lordship, actually, there were two applications of Miss J 11 of 2006, Lordship. Miss J 11 of 2006, first application which was condoned by this Honorable High Court, Lordship. Thereafter, simultaneously, next one more application was there for restoring the case, Order 9, Rule 9, Lordship. That was also there. The learned district judge, civil judge says, no, ki 11/2006 is decided by the High Court, Honorable High Court, but the Miss J 12 is not decided by the High Court for restoration. Then I would like to draw your Lordship attention at page number 10 of the judgment of High Court, Lordship, Honorable High Court, at para 4. Para 4, Lordship. Where both the application has been decided here. At para 4, the applicant file an application under Order 9, Rule 9, along with application under Section 5, Act praying for setting aside of a dismissal of the judgment. Both the application was decided, but they say, no, you go again because Miss J 12 number is not mentioned. In fact, both applications had been decided. This is the case on.
Where is the impugn order? Order dated 13.
What is
Nine.
date? There is a page number 14 left. Of the district clerk, Lordship. Civil judge. Same matter as ditto matter which was under earlier Miss 11 2006. Both are same.
And where is this order dated 25/3/2024? 2004.
I think he did the next one.
This title suit arbitration was dismissed for default when?
Not the-
In the year 2004.
Lordship, it was dismissed in 1994. It is correct. But the record was clubbed with some other record which was not traceable for long time. For that purpose, the matter was made a dismissal for default.
By which order?
This MS arbitration number 13/94 in synopsis.
Where is that order? Page number?
I think he
The
did not annex.
order I have not enclosed, Lordship,
He
because
didn't annex that order, no.
I have not done it because
So which order you are impugning now?
I'm coming for the order of the
That order is required.
Lordship.
That order is, you are against.
Lordship, that has already been decided by Honorable High Court.
No,
earlier.
no, you first, on facts, let us be clear. You filed an arbitration suit
Lordship.
which was dismissed for default.
No, it is not like that. I have arbitration, arbitrator has given the award. Lordship, then that was set aside by the Honorable the civil judge. But the record of that was, it was not clubbed with other documents which was not traceable. Only we want to deposit that 94 record because that helps me in pleading. It is nothing to
No,
consult
no,
with the
no,
court.
Mr.
Lordship.
Against which order you are preferring this?
Lordship, against order, Lordship, para 14,
19.3.
page 14, Lordship.
19.3. So it refers to an order passed on 25/3/2004. Unless that order is before this court,
That is,
that
He will file additional affidavit.
you place, that is required.
that is 13/94, Lordship.
Yes, no, order dated
25.
25/3/2004.
Going cost efficient, 25. Okay, okay, Lordship.
That you place that order on record.
Lordship, please.
Third, Mr. Ghanshyam Das Dhiman, petitioner appearing in person. Also, Ms. A. Gayan Lanet, Central Government Council for the respondent. Lanet, petitioner appearing in person has prayed for some time for bringing on record the order dated 25/3/2004 passed in title suit within bracket arbitration number 3/2003/1999 by filing an additional affidavit. The prayer is allowed. How much time will you require?
Lordship, 1 week on this.
After 1 week, we have puja vacation.
Immediately after vacation.
Immediately after, let this matter be listed again.
This is October. Oh.
Vacation.
21. Then may it be on 21st, Lordship.
On 21st of October 2020.
Of late, Lordship.
My lord, IA 612, IA 612, my lord.
612.
Yes, my lord.
This is for
My friend appeared for respondent number 1. The
setting aside abatement.
abatement and for substitution.
Who died?
Respondent appellant number 24.
Appellant number 24.
24, my lord.
When he died,
That is, I don't.
whether this application is within the period of
Yes, yes, my
limitation.
lord. I expired on 11/10/2023. Within limitation, we filed it, but abatement, I also filed an abatement.
Okay, this
setting
is
aside
within
for-
limitation.
100%, 100%. Yeah, 100%, okay. Yeah.
Abatement আছে নাকি? তাহলে
You have
limitation-
any objection, Mr. Ghosh?
I don't have any objection. But
Abatement দিব লাগে।
huh?
30 days হলে abatement দিব
Since
লাগে।
there is an abatement, my lord.
No, I actually 30 days. Then abatement is to be required to be filed, my lord, setting aside abatement. So I filed a substitution, my lord, within time. I filed
Then
substitution.
abatement is not required.
Not required.
No, when
Within
the,
90 days, if it is filed, then there will be no abatement.
yes,
After 90 days,
again 60 more
60
days
more days.
60 more days.
for filing setting aside abatement.
Yes.
It is not
If,
required.
if it is not within that period, you have to file condonation
Yes,
application.
lord.
Yes.
Is it within that period?
Yes, we filed it on
16/2.
yes, my 16/2. 16/2 and expired on, my lord, 13/10. 13/10. 23,
Yes, it is
within time.
within time. Third, Mr. J. Ahmed, learned counsel for the applicant.
1310.
2023. On February,
Then I-
Also heard Mr.
February, I guess.
S. K. Ghosh, learned counsel for the.
Hmm.
You are appearing for
That's number 1.
Only for respondent number 1.
respondent number 1. This application under order 22, rule 9 of the Code of Civil Procedure, 1908 has been filed by the applicants / appellant for setting aside abatement on death of on death of appellant number 24, who had passed away on 1/10/2023. Stop. The application has been filed within the period of limitation. Why you where have you mentioned the reasons
My lord,
for not substituting the legal years within 90 days? The applicant has mentioned the reasons for not continuing within the appeal before it got abated on the death of respondent number 1 in paragraph number 4 and 5 of the application. Stop. Learned counsel for the respondent number 1 has not objected to the said prayer. Hence, the prayer is allowed. And the abatement of the appeal on death of Appeal number 24 is hereby set aside. And this interlocutory application is allowed. Substitution petition is there.
Yes, my lord. Yes, I think it will be good. I have a password, yes, sir. 6.
3568.
612. I have a password.
What are the IAs? One is setting aside abatement.
And one is for substitution.
That is 3437. And what forward 3468 is filed 68.
Regarding,
3568.
they have not taken steps on respondent number 10, 20, 21, 26. Other,
Other, my lord, already struck of their name. They are a former dependent, they are not contesting the suit.
No, let us take up 3437.
3437.
Substitute. You have any objection?
No.
3437. Heard Mr. J. Ahmed, learned counsel for the applicant. Also heard Mr. S. K. Ghosh, appearing for respondent number 1.
My lord, it is a separate petition, my lord.
What is this?
So far as appeal number 24 is concerned, there is another petition for substitution.
Which one?
That was I am facing.
You prepare yourself, then we will take it up.
So many.
Will,
I,
Mr. Ahmed, you have many IAs.
My lord.
On a piece of paper, you write down, we'll take it up as next item. In the meanwhile, you prepare. Let
Oh,
him,
my lord, my lord. Yes, I-
no, you prepare.
yes, sir.
We'll take it up as next item.
Please, your lordship. Lordship, here, initially, my lord, the appellant expert, we filed a petition, delay petitions, abatement and substitution of the substitution of the legal hires, my lord. When notice was issued, my lord, we got a report of respondent number 4 and 6 expired. So we have filed again petition for delay, abatement and substitution of respondent number 4 and respondent number 6. So my lord, here today, with regard.
How
to-
many IAs are there?
Total there are 8 IS. If my lord for now, for today, my lord, the notice.
There was, how many appellants?
One appellant. Originally one appellant, the appellant expired. So we have filed IA number 1185, 1186 and 1187 for delay, abatement and substitution. Notice was issued. There the report came from the Gaonbura that the respondent number 4 and 6, the original defendant number 4 and 6 expired. So in due course, with regard to defendant number 4 and 6, we have again filed for the legal, with regard to delay, substitution and abatement. So my lord, for today, my lord, the notice will go in IA number 2996, my lord. 2996, 2997, 2998, 2999 and 3000.
Section 5 করে যাবে এই section 5 of Thasta.
Section 5. So with regard to 2996 and 2998. Two 2996 and 2998.
You're appearing for?
I am appearing for respondent number 1 here. So when she filed, she has filed 2 more petition for substitution. And there is.
Substitution in
Appeal.
IA,
No,
not
no, it will be in appeal.
in May, but unless appeal is already abated.
Yes.
It has to be, abatement has to be set aside. Only then substitution will be there in appeal. So first we will hear the setting aside abatement. let us set aside the abatement, then otherwise she will be, you have filed this 2996 in appeal, or
In appeal, my lord.
appeal is no longer
No,
there.
appeal is not there. In IA while sending, yes, my lord, that is true. Yes.
So appeal has to be, the abatement has to be set aside first
Of the appellant.
of the appellant, because only one appellant is there.
Then I thought because this petition for substitution cannot be heard without hearing LR of respondent number 4 and 6. Because they are also, because it is time barred, a right have accrued to them.
Yes.
So
So notice has to go
has to
to,
go. Only then this
yes,
petition
yes,
may be.
yes.
This one, so 2996 and 2998.
In 2996 for setting aside this is only as regards setting aside of abatement of appeal. You have filed on abatement of appeal. You have filed an application for condoning the delay in filing setting aside abatement application. When the notices went, you came to know that 2 respondents have expired.
Fine.
So you have to take steps for
Yes.
substituting legal heirs of those respondents in that setting aside application,
Appeal.
not in appeal.
Yes.
So again, there is a delay there.
Delay.
Delay.
And that delay is, I think, I don't know
Yes.
how many days.
Yes, even my lord, after coming to the delay from the Gabra report, it came to know that 2902 days delay. It was even before filing the original appeal only. He expired long back. This was not in our knowledge.
Okay, we'll issue notice.
Yes, ma'am.
Heard Miss S.G. Barua, learned counsel for the appellant, also heard Mr.
BK.
B.K.
Jain.
B.K. Jain, learned counsel appearing for
Respondent number 1.
respondent number 1 in 2996. This,
No, no. 1185,
which one?
the original 1185.
That is condonation petition, first condonation
First
petition.
condonation delay, 1185, 2024.
Order is passed in that case.
Same case. 1185, 2024.
This 1185 we can take up only after condoning delay.
This is 1185 is
In
regarding
1185
is condonation of delay of first petition.
first petition,
Yes. And in the IA 2996 and 2998, I have only made parties with regard to the relief.
with regard to
So with regard to the substitution.
Delay
the
instruction.
Delay instructions, with regard to those who will be substituted in respondent number 4,
4 and 6.
4 and 6. With regard to 2996 and 2998, only the notice will go, and my lord, with regard to 1185, my senior appeared already.
Appeared only for respondent number
1.
1.
In 1185.
Okay, in 1185 application. In 1185, you have to substitute the legal heirs of respondent number 4 and 6.
Yes.
4 and 6. It appears from in 1185 Agor to Likhi. It appears from records that when notices were sent to respondent number 4 and 6, same returned with report of process server to the effect that both the respondents have expired. Stop. The legal heirs of both the respondents have to be substituted in their place. However, London counsel for the petitioner has filed 2 more interlocutory applications, namely 2996 as well as 2996 for condoning the delay in setting aside the abatement of abatement on the death of respondent number 4, as well as for substitution of his legal heirs, as well as IA number 2998 for is for
For respondent number 6.
for
Forty.
condonation of delay in setting aside abatement and for substitution in respect on death of respondent number 6. Stop. This instant application shall be heard only after disposal of those 2 interlocutory applications. Stop. Now in 2998. Application under Section 5 of the Limitation Act, Command 1963, has been filed by the applicant in IA 1185/2024 for condoning the delay of 1960 days in filing the application for abatement, for setting aside abatement on death of respondent number 6 and for substitution of legal heirs of respondent number 6. You are appearing for respondent number 1.
In 2996 and 998, they are not made parties.
Issue notice to the. Who are these respondents?
Respondents will be the those will be the, 2998 will be the respondents from the death of respondent number 6, they are legal heirs. They are legal heirs, and with regard to 2996, they are the legal heirs of respondent number 4.
Issue notice to the respondents. The petitioner shall take steps for issuance of notice by registered post with AD, as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. In 2996 also, this application under Section 5 of the Limitation Act 1963 has been filed by the applicants in connection with IA number 1185/2024 for condoning the delay of 2902 days in filing the application for setting aside abatement on death of respondent number 4, Debirang Hajong, and for substitution of his legal heirs. Issue notice to the respondents. You have to file actually separate application. For setting aside abatement, one
Separate applications, my lord. This is only delay, my lord.
condoning the
On delay, abatement and substitution,
issue note.
this is only delay, my lord.
The applicant shall take steps for issuance of notice upon the respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
My lord, the notice has only gone with regard to the delay petition now. The
Yes.
abatement and substitution are there. right?
Yes, after delays
Yes.
condoned,
Separate petitions are.
list
Lordship,
accordingly.
since I am contesting your lordship, a copy may also be served upon me. I
Yes.
will also see what is there.
The I'm not passing orders, you serve the copy.
They are not parties of the.
It will
Under interim orders passing, I will make.
What
Yes.
interim order?
There was this stay, my lord. There was the stay of executive initial, there was.
When the
NDRS.
appeal is where interim order has been passed, where
in
Yes,
appeal.
appeal.
appeal
It
has
is not
been,
there.
appeal is not.
Can a date be fixed, my lord, in this matter?
After 4 weeks,
So-
that is, Dutate, let the notices are returnable in both the cases on 6th of November 2020,
I said any date other than 6, my lord, any date.
on 7th of
My
November.
lord. Yeah, the lordship, your lordship, even I have number of IA on the death of respondent as well as.
Item number
applicant.
40,
Yes, your lordship. Now, first one is. Your lordship, 1464.
1464.
Yeah, this is a petition for delay in filing the petition for substitution. And we have filed 3 petition here for condemnation of delay, substitution, as well as abatement. Now, as per office note, your lordship, may kindly see that is 31/7/2024, your lordship.
Who died?
Respondent number 5
When he died?
on 23/7/2022.
This application is for condemning.
Your lordship.
This is the appeal has abated
No, appeal not abated because.
against respondent number 5.
Yes, your lordship.
Against respondent
Again,
number.
only against 5.
So you want to set aside abatement first.
Abatement, then 6 and 5. What happened here, lordship, can you see the order dated 31/7/24? Office note,
31/7/24 in
in the IA 1464.
1464, there is only one order,
Yes, that
27/5/24.
31/7/24.
Mhm.
Office note, your lordship.
Yes,
Yeah, the notice, SR received in so and so, served and duly served. Here, what happened? They are again saying that no states they could receive years till date in IA 1466. What happened, your lordship? We took steps, there as per office note only in the section 5 petition, but no steps were taken under section order 22, rule 9, as well as order 22, rule 4 for substitution. Only steps were found in respect of section 5 petition, and which was duly served. But nobody has appeared, although notice received under section 5 petition. You are appearing?
2 and 7.
2 and 7.
no, this section 5 petition is for condoning delay
Delay.
in substituting.
Yes, your lordship.
But you have to file an application for condoning delay in setting aside abatement.
That is fine, it is there, your lordship.
Where?
That is, it is there in the record, that is, petition number, IN number 1468.
1468B. First, the abatement has to be set aside.
Your lordship. So, since no steps taken on 1468
1468, so.
and 1465.
1468 আমাক দিয়া নাই কপি
দিছো copy? লৈ লওঁ,
বাকি এটা পাইছো
লৈ লওঁ। এই মনে কি কৈছো copy?
1468.
Inadvertently, why the clerk did not take steps here, we don't know. Only today, after going through the records, I found these things. Otherwise, notice was served in section 5, already served in all the legal years. But the main 1468, no steps was there. Office note says like that.
1468 is not there.
It is here, not to be a file, it is there.
1468
of 2024.
is not even in the cause list.
Nine.
না এটা
It is last. It is there last. What is the last? 1468, last, एकदम last one. 1468. 1464, 1468.
68 is not there.
Let it be then, it is there, and we have filed it.
That is regarding
That is regarding setting aside abatement, your lordship. 1468.
no one query. 1468 has been filed for setting aside abatement. That is barred by limitation. So you have to file an application for condoning the delay.
It is, that is the 1464.
1464 is for condoning delay in filing substitution application only,
Yes, your lordship.
not for setting aside abatement. You have to file an application for condoning delay in preferring setting aside abatement also. Because there is a limitation for setting aside abatement, 150 days.
I've explained there in 1468. Huh? I've explained those delay in 1468 in my petition.
No, but that is for filing an application for substitution. For filing an application of substitution is a different thing.
Yes.
For setting aside abatement, it is a different aspect. Both will be judged on their own merits. Because they may object to both the applications. So you have to file an application for condoning delay in filing the setting aside abatement application, if it is not within 150 days. And apparently it appears that it is not within 150 days. So you have to file an application for condoning delay in filing setting aside abatement application.
I may be given.
Yes. Heard Ms. K. Yadav, learned counsel for the applicant, who submits that, who prays for some time for filing application for condoning delay in preferring the application for setting aside abatement of appeal on date of respondent number 5. Respondent number 5.
Yes, you know.
Respondent number 5. Also heard Mr.
Also,
R.
2 and
Sharma,
7.
appearing for respondent number 2 and 7. The prayer is allowed. Let this matter be listed after puja vacation on a date to be fixed by registry.
Next, your lordship. Next case is IA number 1697.
This is regarding,
It is regarding death of respondent number 1.
one six,
1697/2022. IA
1697. No, quest. Setting aside abatement.
here,
Which one is your setting aside abatement application?
IA 1697/22.
No, in respect of respondent number 5.
Respondent number 5.
Earlier, yes.
Earlier, setting aside abatement is your lordship, 1468,
1468 of order.
24.
Need to dictate Korilu. That order will, in 1468, we are passing orders that you are seeking time for preferring an condonation of delay application. 1468. No, 146859, okay. We are not getting the records. 1468 is connected with RSA 23,
Yes, your lordship.
but it is not there on record.
Our case is it বেলেগ case. MFA, আমার তো RSA.
লিংক আছে
কিবা গন্ডগোল আছে, দেখো না?
বাইদেউ আপুনি চেক কৰি বাইদেউ
হা?
আপুনি ৰেজিষ্ট্ৰি চেক কৰি
Registry
লওক
চাব লাগিব।
আপুনি registry
এইটো বেলেগ case. MFA.
No, this 1464 is for what purpose?
1464 under section 5.
Condoning delay for substitution.
Yes, your lordship.
Then miss case
14.
3414. Next one,
Your lordship, let me see.
you make a list.
Your lordship, 3414 is there.
Is
That is respondent number 3.
again for substitution.
Yes, your lordship.
And 3415,
3415 condonation delay and I'm showing your lordship. The 3415 section 5 petition,
for what purpose?
delay of 136 days. Petition, miss case 3414 is the section 5 petition and 3415 is under 20, order 22, rule 4.
For substitution.
Yes, your lordship. And 3416 is 20, order 22, rule 9,
Setting aside abatement.
abatement.
In respect of,
Respondent number 3. There is delay of 136 days,
in filing setting aside abatement also, that delay has to be condoned.
as your lordship has pointed for now.
In respect of respondent number 5 and respondent number 3, you have to file an application for condoning delay in preferring setting aside abatement application.
I do. Do.
In 3416. 3416 order leaving. Argues K. Yadav, learned counsel for the applicant, also Mr. R. Sharma, learned. counsel for respondent number
2 and 7.
two and 7. This application has been filed under Order 22, Rule 9 of the Code of Civil Procedure for setting aside abatement of appeal on death of respondent number. Whose
Respondent
death,
number 3,
whose name
Matiur Rahman.
on death of respondent number 3, Matiur Rahman. However, this application is not within the period of limitation, and therefore learned counsel for the applicant prays for some time for filing an appropriate application for condoning the delay in preferring the instant application. The prayer is allowed. Let this matter be listed after puja vacation on a date to be fixed by registry. So respondent number 3, you file condonation delay application. Respondent number 1, that 1468 is not traceable. That is for 1468 is
Lordship, 1, 4. That is respondent number 5, your lordship.
and 1464 is also for respondent number 5.
1464, yes, 1468.
1464 होते हैं तो order
Yes, your lordship.
1464 लिखिए. Heard so and so. Learned counsel for the applicant has submitted that the applicant has filed an interlocutory application which was registered as IA within bracket C 1468/2024. For what purpose you have filed that?
Which one?
1468
1468, setting aside abatement.
for setting aside abatement. However, same is not traceable along with the records. Registry is directed to place the said record of the said IA along with this application on the next date fix. List this matter again after puja vacation on the date to be fixed by registry. What is 2175?
21. Your lordship, that is 2175, that is appellant number 1. Appellant number 1 died, your lordship, and the
Appellant died this time.
appellant and the legal heirs of the appellant has come before the court with a petition prayer that they may be allowed to be substituted in place of their father.
How many appellants are there?
There are appellants, 6 appellants. 6. 6 appellants are there, and appellant,
When he died?
your lordship, he died on.
10 years ago.
Yes, your lordship. Your lord, petition was filed under Order 1, Rule 10, read with 22 for substitution edition of their legal heirs of the appellant number 1. And delay was 492 days at that time.
For condoning the delay,
Condoning the delay, petition is 1764.
that has to be decided first.
Yes, your lordship. The 3 petitions were filed. Initially, your lordship, we filed only 1 petition for under Order 1, Rule 10. Then court asked that no, you filed a petition for condonation delay as well as abatement. So we have to file later on. We filed these 2 petitions. And your lordship, notice were also served. Only respondent number 8 and 9 respondent number 8 refused.
This is still at the stage of notice.
Notice were issued, your lordship,
Okay, we are fixing this on a fixed date after puja vacation.
for
In 2 or 3, I have already passed orders for
filing petition.
filing
for,
petition. You
delay.
prepare a chart on the next date with every miscase an IA, what
Yes.
for which is fixed. Then, because orders are also otherwise confusing,
Yeah, that's true, your lordship.
so it has to be properly arranged. In 2175,
Yeah, notice was served, your lordship. Order dated 9/4/2024. Office note may kindly be looked into.
yes, notice were served.
9/4/2024. Otherwise, your lordship, here the appellant died, legal heirs themselves have come before the, as a applicant to make them party. So the other respondent, what they have to say here?
We'll hear this on next date. If there is, they have no objection, we'll allow it.
Because only two have, two and others are not appearing. All the notice was served on all the respondents earlier. At the time of admission, after admission, only two have appeared. Now others are not appearing, your lordship. And in the meantime, thereafter admission, one by one is dying. One respondent died, the appellant died, again respondent
How
died.
many appellants are there?
Appellants are 6, your lordship.
Out of which one has died.
One, no, your lordship, not one. Murad Imam died, then number 6 also died, your lordship. Her legal heirs also already on
Heard
record.
Miss K. Other and counsel for the applicant also heard Mr. D. Das, R. Sharma, appearing for respondent number 2 and 7. On perusal of office note dated 9/4/2024, it appears that notice is issued to respondent number 5, 6A, 6B, 6C, 6D, 6E, and 6F. 8 and 9 are duly served. And respondent number 6, G, has refused to accept the notice. Stop. On the basis of the report of the process server, the notices are held to be duly served on all the above aforesaid respondents. On next date, we will pass orders on this. Let this matter be listed again on. No, a fixed date then. I am giving a fixed date on 6th of November.
Your lordship, I will be out of.
He
India at
suggested
that
it.
time. I will come in December only, after 10th of December, your lordship.
This is already a very, okay. After Puja vacation on a date to be fixed by registry. Registry will fix.
I will be not here. I will be out of India, your lordship.
Suggested date,
And after 10th December.
16th of December.
Yes, that will do.
16th of December. On the next date fix, you come up with a chart of
Yes, your
all the IAs. For what purpose, which IA has been filed and what is the stage.
I have, but still I will make more progress.
Otherwise, it is already a delayed
Yes, your lordship. I
in
have to file petition for setting
appropriate
aside.
petitions.
Yeah, then only. No more petition is there, your lordship. The next again one. Which one? 1-3. 1764.
Remaining, we will pass orders on next date.
Yes, your lordship.
After everything is made clear.
Yes, your lordship, better. I will also require time to make.
Baki Bilakot, list this case on 16th of December
Yes, your lordship.
on
Much
request of learned counsel for the applicant. 16 December.
Much obliged.
Wait, please. Wait, please, my lord, item number 51, my lord, my friend is appearing. My lord, matter may be taken up after vacation, my lord.
Heard Mr.
G. Goswami, my lord.
G. Goswami, learned counsel for the appellant who prays for an adjournment on the ground of personal difficulties. Also heard Mr. D. Rathi, learned counsel appearing for the respondent who does not have any objection to the said prayer. The prayer is allowed. Let this matter be listed after puja vacation.
Lordship, but 12th November, if the date may be fixed, it's an old matter.
No date. Puja vacation on a date to be fixed by register.
Lordship, there is another matter which may learn it, right? Item number 50, Lordship. My lord, actually, my colleague, my lord, Mr. MS Uma Chakraborty is appearing in this matter. He rang me up, my lord, says ill, my lord. So, my lord, item number 50 may, same order may be passed in item number 50 also, my lord. And Lordship, in that matter, we have not received a copy of the appeal, the reason which.
Item number 50, ek order digo. Only you are appearing
On behalf of.
Mr.
Uma Chakraborty.
U. Chakraborty,
Yes, sir.
counsel for the appellant. Baki same order.
Lordship, we have not received a copy of the appeal. In
The-
that matter.
The appellant is directed to furnish a copy of memo of appeal along with annexures to the respondent before the next date fix. Yes, Mr. Ahmed.
My lord, that item, I found two IA not there.
Deka, who has done it counsel for the petitioner. Also, Mr. P. Upadhyay, learned counsel for respondent. Learned counsel for the petitioner has submitted his written gist of argument earlier. Today, the learned counsel for the respondent has submitted the written gist of argument. So, hearing concluded, judgment reserved.
Obliged.
Let to record the person. Written argument. Yes.
My lord, here, IA 612,
Yes.
actually in this case, my lord, the substitution petition unmistakably not on record. There, my clerk not file, I just now checking,
Not filed.
not file, because my lord, there is some cost title, there is a mistake. Same file a petition under order 22 rule 9. And substitution petition also it should be 3, rule 3. That is why that was not, substitution not listed.
Now, what is this? 3568?
3, 5. 366 is the condemnation petition. madam.
It is.
It is original condemnation petition, my lord.
No, order, this is order 22 rule 9 petition. 3568.
3568 condonation.
Condemnation,
Filing appeal.
filing appeal.
And 612?
6,
612 is setting aside of abatement for filing substitution petition with respect to appeal number 24.
but here substitution petition is not there.
Now, what is your prayer?
I will,
Without substitution, how can?
but everything file, but
Cannot-
substitution also I have the copy them, but there is a cost title mistakes. That is why.
Now, where I will pass orders? In which case?
Now, order is not necessary here in that case, I will file.
My lord,
there.
in IA 612,
2, I will file. substitution
order
petition.
maybe passed.
612, so.
612.
61 of 2024.
In IA 612, nahi, ye to aise. Heard Mr. J. Ahmed, learned counsel for the applicant. Also heard Mr. S. K. Ghosh, learned counsel for the respondent. Learned counsel for the applicant has submitted that due to inadvertence, the applicants have not filed any application under order 22 rule 4,
Rule 3, appellant, right?
rule 3
Yes.
for
However, I asked my clerk to check it properly.
We'll see for substitution of the legal heirs of this appellant number
24.
24. And praise for some time for filing the same. The prayer is allowed. Let this case be listed after puja vacation on a date to be fixed.
And now my lordship kindly see IA number 3437.
3437. What is this?
This is also rest number 26 expired. But here IA number 3260 and another IA are not listed, my lord.
3260 is for
3260 for condemnation of delay. How to go?
and 3260 আসেনি?
At 3257 of
Or-
2022.
or-
For the setting as an abatement. Those two petitions not here.
Heard Mr. J. Ahmed 3437 of लिखिए. Heard Mr. J. Ahmed, learned counsel for the applicant. Also heard Mr. S.K. Ghosh, learned counsel for respondent number 1. Learned counsel for the applicant has submitted that the applicant has filed another 2 interlocutory applications, namely IA number 3260/20
22.
2022 for condoning the delay in filing application for setting aside abatement, as well as 3252/2022 for setting aside abatement on death of respondent number,
Appellant
26.
number, appellant number.
26.
Appellant
Appellant
number.
number
appellant number
26.
26. And said interlocutory applications are not on record. Sub-registry is directed to list this matter along with the aforesaid applications on the next date fix. List this matter after puja vacation.
My lord, a date may be fixed.
List this case after puja vacation on 30 October. 30 October 2000. Here, setting aside abatement is within period of limitation.
But limitation. Now here, no.
Then you have to file an application for condoning the delay in filing setting aside abatement also.
Right.
Look at that aspect also.
I filed here.
My lord,
I already filed.
already appeal has already been abated. Because
No,
respondent,
therefore,
no, with respect to 24 and 26 is appellant. So far respondent number 7, 8, 9, 11, 12, 14, 16, 17, 18, 20, 31, 21, 24 and 29 expired.
for that you have to take
No, no.
steps.
We have taken steps.
All are died.
The
So
lordship
it
kindly
has
order.
already been abated.
No, my lord. In that case, those respondents were not contested the case, title suit also. And in appeal also, they did not contest the case. And even during the filing of the title suit, they are the plaintiff. They are not taking any step regarding those persons. Those persons, they have not taken any steps. Again, they have filed appeal. Appeal also, they have not taken any steps, my lord. It is their fault, my lord. So
No,
that is why they have been already started.
no, if appeal is abated, then you will face the consequence
Yes,
during execution.
yes.
Okay, let it be fixed after puja vacation on 30 September.
Because they will be, because they are not taking any steps. I filed one affidavit showing that those performance defendants were expired before filing of the suit. They made them party. Then legal hairs are not gone.
On-
Again,
their name may be
they
struck
file a
off.
bill, my lord.
At
No.
their instant, their name may be struck off before in this appeal.
Not today.
Because of this, the appeal is not proceeding and
No, no, we have-
without admitting without condoning delay, they obtain the stay order, and my execution has been stayed.
No, you pray for vacation of stay order. If
My lord.
Stay order, kindly see order passed in the stay order, my lord, in case number, my lord,
so,
422.
4227. Returnable till returnable date. Thereafter, it has not been extended at our objection, my lord,
not extended,
not extended.
then it is lapsed.
It is left, but the execution proceeding has been stayed on this petition, or on this order.
You inform the executing court that there is no,
They already informed what happened, my
there is
lord.
no
We
stay.
have already
They
informed.
already informed what happened, my lord.
We have already.
Another
informed.
other persons who are not made party to that suit, they filed under suit, my lord. Against
That
that
is
judgment,
separate
my
thing.
lord.
That is separate.
Separate, that judgment. For challenging that judgment, my lord. Because they are not made party.
Because of
That
this
is
order,
I also filed one this
execution is
affidavit,
not.
bring on record of the.
Okay, we'll see after
Yes.
30th. Let
And
the
their
sir-
name already stuck of, my lord.
And execution, part of execution has already been completed.
now there is no stay.
Part, execution means the partition has been made, but possession is not giving because of this stay order.
Another suit also already filed, my lord.
That is why they are
Other
delaying
persons.
this case by not filing in appropriate application with respect to appellant number 20, 24 and 26 in time. One application
I am
filed,
disputed his argument,
another
I am
application is
disputed
not
my head.
filed.
Baseless argument, my
It
lord.
is not disputed. It is on
Baseless
record.
argument, my lord.
Not today, not today.
It is
On
not disputed. This is on record that they have.
I
not
file an
this
affidavit, my
application.
lord, in Los Angeles, see, in plain, they have not taken the steps of those persons.
on 30th.
It is their duty, my lord.
No,
you
no,
take-
not with respect to 38, 24, 26, appellant.
No, we are not taking up
Well,
those matters now.
My lord, we may delete their name also, no problem. I believe no, there will be no harm. Suppose I delete the name of those appellant, I will not go. I will delete their name, maybe.
We'll
My lord.
we'll
Yes.
hear your prayer on the next
My
day.
lord. Yes, my lord.
Next day. Let him take steps.
Yes.
May I please, your lordship? Lordship, item 41.
Item number?
41. Lordship, substitution petition, your lordship, with respect to the respondent. Lordship, he died on 25/5/2024. We have filed this application on 21/8/2024.
Within the period of limit. Respondent number? Sole respondent.
Respondent, your lordship.
Heard Miss F.N. Zaman, learned counsel for the applicant. This application under Order 22, Rule 4 of the Code of Civil Procedure has been, Civil Procedure 1908 has been filed by the applicant / appellant / petitioner in connection with Civil Division Petition number 16/2023, praying for substitution of the legal heirs of the sole respondent. Stop. It is submitted by learned counsel for the applicant that the applicant came to know that during pendency of the connected revision petition, the respondent Pierre Uddin Mazumdar had passed away on 25/5/2024, leaving behind 3 legal heirs whose names are mentioned in paragraph number 3 of the petition, namely Iftikhar Alam Majumdar, Intikhab Alam Majumdar, and Nilofer Yasmin Majumdar. The applicant has prayed for substituting the names of the legal heirs in place of the deceased respondent. Stop. The prayer made by the applicant for substitution of the legal heirs of the deceased respondent is within the period of limitation. Stop. The prayer is allowed. The registry is directed to substitute the names of legal heirs of respondent in his place as respondent number 11, 12 and 13 respectively. Stop. This interlocutory application is accordingly allowed and disposed of. The registry to list the connected CRP after making necessary rectifications after reopening after puja vacations on a date to be fixed by registry.
A pleasure.
May plead your lordship. Lordship, kindly take up IS civil number 2916 of 2024, lordship. This is an application file under order 23 rule 3, lordship. Lordship, what happened in this case, both the parties may compromise between themselves, lordship, and they executed a compromise decree, lordship. I have annexed along with the application, lordship, page 13, lordship.
Yes. Page
13, page 13 is the compromise agreement, lordship.
so it will be disposed of on
Yes, on the basis of this compromise agreement, lordship. My land and pen appears on other side, lordship.
you have no objection. Heard Ms. P. Chakravarti, P. Bhattacharjee, learned counsel for the appellant slash applicant slash appellant. Also heard Ms.
D. Pathak on behalf of Mr. R. Day.
D. Pathak appearing on behalf of Mr. R. Day, learned counsel for the respondent. This application has been filed by the applicant slash appellant under order 23, rule 3 of the Code of Civil Procedure, 1908, praying for disposing of the connected writ appeal on compromise. Learned counsel for the petitioner, learned counsel for the applicant has submitted that the parties to the appeal have amicably settled their dispute and reached a compromise settlement amongst themselves. And in that regard, a deed of compromise agreement has also been executed
12/4/2021.
between the parties on 12/4/2021. And therefore, she submits that the connected regular second appeal number 34/2009 may be disposed of on the basis of the compromise settlement, on the basis of the compromise agreement reached between the parties. Learned counsel for the respondent also agrees to the submissions made by learned counsel for the appellant. Stop. Considering the submissions, I have gone through the compromise agreement, which is annexed as annexure A to the instant application. In view of the submissions made by learned counsel for the applicant as well as respondent, and in view of an amicable settlement reached between the parties, the connected regular second appeal is disposed of on compromise. On compromise. If order has to be passed in
Second
our
appeal.
second appeal also. On compromise. This interlocutory application is accordingly allowed and disposed of. In second appeal, again, heard Ms. P. Bhattacharya, same parties, same council. In pursuant to the orders passed in IA within bracket civil 2916/2024 on 30/9/2024. This appeal is disposed of on compromise on the basis of amicable settlement reached between the parties. Prepare decree accordingly. Let the compromise agreement dated 12/4/2021 be part of the decree. Be part of the decree to be prepared. This appeal is accordingly disposed of.
Regarding substitution of legal layers of appeal number 1, my lord. The appeal is, as per office record, appeal is barred by 276 days, my lord. Two nine eight three is petition for condemnation of delay, my lord.
This is 2983 for for condoning the
2983, section 5.
section 5 of the Limitation Act for setting aside, for condoning the delay of 273 days for setting aside legal days. Okay. You are appearing for all respondent.
Yes, so respondent, my lord.
You have any objection? Heard Miss B. Devi, learned counsel for the applicant. Also heard Mr. S.K. Ghosh, learned counsel for the sole respondent, for the respondent. This application under section 5 of the Limitation Act, 1963 has been filed by the applicant/appellant for condoning the delay of 276 days in setting aside abatement of appeal on death of the appellant number 1, within bracket Abdul Rahman Mia. Stop. The appellant number 1 died on 21/6/2023. The learned counsel for the applicant has submitted that she has explained the cause for delay
5 and 6.
in paragraph number 5 and 6 of the said of the instant application. Stop. Learned counsel for the respondent has not objected to the prayer made by the applicant in this case. Considering the submissions of the counsel and as well as grounds stated in paragraph number 5 and 6 of the application, this court is of considered opinion that the said ground may be regarded as sufficient cause for preferring the connected application for setting aside abatement within the period of limitation. Stop. For the reasons aforesaid, the delay of 276 days in filing the application for setting aside abatement by the appellant is hereby condoned, and this application is hereby allowed. This interlocutory application is accordingly disposed of. Now, where is setting aside abatement?
Yes.
Which one?
2984.
298. This application heard so Duta naam likhibo. This application under Order 22 Rule 9 of the Code of Civil Procedure has been filed by the applicants/appellants for setting aside of the abatement of appeal on the death of appellant number 1, late Abdul Rahman Mia, who has passed away on 21/6/2023. The appeal had abated in respect of appellant number 1 after 90 days of the date of his death. Stop. However, stop. It also appears that by order dated 30/9/2000 IAC number 2983/2024, a delay of 276 days in preferring the instant application was condoned. Learned counsel for the respondent, Shri S.K. Ghosh, has not objected to the prayer for setting aside abatement. Considering the submissions of learned counsel for the parties as well as for the reasons mentioned in the application, the abatement of appeal on death of appellant number 1 is hereby set aside, and this interlocutory application is accordingly disposed of. This is for substitution.
2985 for substitution.
This heard Ms. B. Devi, learned counsel for the applicant, also heard Mr. S.K. Ghosh, learned counsel for respondent. This application under Order 22 Rule 3, read with Section 151 of the Code of Civil Procedure, 1908, has been filed by the appellants praying for substitution of the legal heirs of the deceased appellant number 1, late Abdul Rahman, who had expired on 21/6/2023. Learned counsel for the applicant has submitted that the names of the legal heirs of deceased appellant has been mentioned in paragraph number 4 of the application, namely Zamirun naam yaar par likhe logo 4 or para 4 at page 4, namely so and so. Learned counsel for the respondent has not objected to the prayer for substitution of the legal heirs of appellant number 1. Stop. Considering the above facts, the prayer is allowed. the registry is directed to substitute the aforesaid legal heirs of appellant number 1 in his place in the memo of appeal as respondent number 1 within bracket small Roman 1 to 1 within bracket small Roman 9 and list the appeal, list the connected appeal again after
Yes, sir.
puja vacation after making necessary corrections.
This priest memo is to be submitted. Otherwise, it will not reflect. it
Cost
in the
item will
CIS.
be amended, my lord. I will amend the cost
Yes.
item.
Yes.
I will
The-
submit the amended cost item.
The appellant shall submit the corrected cost title showing the substituted,
Right, my lord, I will submit.
showing the substituted appellants
Amended cost item.
before the registry, before the next day.
Yes.
Fix.
Okay.
List accordingly.
IA number 2993, it is for delay condonation in substitution of respondent number 1, lordship, 716 days delay, lordship.
For
Respondent number 1, substitution of respondent number 1. The respondent number 1 had expired on 18 April 2022, lordship. However, we have come to know only on 6th August 2024, lordship.
notice will go.
I am
So they are
Kapalatnama, I have this. I have-
Whether the appeal has abated after 150 days.
They have filed 3 applications.
Yes, lordship, we have filed 3 applications, delay application, setting aside abatement and substitution, lordship.
Delay application for what?
For condoning the delay, lordship, of 716 days,
In filing what?
lordship, in filing the substitution,
No,
setting
no.
aside abatement.
Have you mentioned it in your application? No, you have mentioned 716 days. Delay in filing what? Where have you mentioned?
Yes, lordship.
Where have you mentioned?
So it has not been mentioned here.
Then it may be treated as a delay application for setting aside abatement.
Yes.
I can record your oral submissions.
Yes.
This, you have any objection? This heard Miss
Yes, story.
S. Todi, learned counsel for the applicant. Also heard Mr. S. K. Ghosh, learned counsel for the, how many respondents are there?
Who responded, lordship?
Who died?
Respondent number 1.
Learned counsel for the respondents. This application under section 5 of the Limitation Act, 1963 has been filed by the applicants / appellants praying for condoning the delay of 716 days in preferring the connected application for setting aside abatement of the appeal on the death of respondent number 1. Stop. Learned counsel for the applicant has submitted that respondent number 1, late Janak Machi, had expired on
18/4/2022, lordship.
18/4/2022. However, the applicant came to know about the same only when,
6/8/2024.
only on 6/8/2024, when the same was
Intimated to us by the
Respondent.
informed to them by the counsel for the respondent. Stop. Learned counsel for the respondent has no objection regarding condoning the delay in preferring the connected application. Stop. The applicant has explained the delay in preferring the connected application in paragraph number 3 and 4 of the instant application. Considering the grounds mentioned by the applicant as well as submissions of the learned counsel for both the sides, this court is of opinion that delay of 716 days in preferring the connected application for setting aside abatement has been sufficiently explained. Hence, full stop, hence, comma, the delay of 716 days is hereby condoned, and this interlocutory application is allowed and disposed of. Now 2994. This have heard Miss
S2D.
S2D as well as SK Ghosh, same. This application under order 22 rule 9 of the Code of Civil Procedure, 1908 has been filed by the applicant appellant praying for setting aside of the abatement of the appeal on death of the respondent number 1, Janak Manji. Stop. The appellant / applicant has mentioned in paragraph number 2 of the instant application the reason for
One A, no? One A, yeah, one.
1A.
Yeah,
reason for not continuing the connected appeal on death of the respondent number 1. Stop. The learned counsel for respondent has not opposed the prayer of the applicant. This court, after considering the reasons mentioned in the application, as well as after hearing the submissions of learned counsel for both the sides, is of the opinion that the appellant was prevented by sufficient cause from continuing the appeal on the death of the respondent number 1 before it got abated, and therefore the abatement of appeal on death of respondent number 1 is hereby set aside, and this interlocutory application is allowed and accordingly disposed of. Substitution petition. Same parties. Next, 2995. Go to ASIL 2994. This application under order 22 rule 3 read with section 151 of the Code of Civil Procedure has been filed by the applicant / appellant in connection with RSA number 53/2018 for substituting the legal heirs of respondent number 1 who had expired on 18/4/2022. Stop. The names of the legal heirs of the deceased respondent has been mentioned in paragraph number 2 of the application as follows. Number নাম দিব ধনেশ্বরী মেধি, পদ্মাবতী, ধনেশ্বরী মাঝি, পদ্মাবতী মাঝি, গীতা মাঝি, দর্পণ মাঝি, and Deep মাঝি. Page number 5 or plus I love. Stop. The prayer is allowed. The aforesaid legal heirs, aforementioned legal heirs of respondent number 1 shall be substituted. The names of the aforesaid legal heirs of respondent number 1 shall be substituted in place of respondent number 1 in the memo of appeal as respondent number 1A to 1E. Stop. The applicant / appellants shall submit a corrected memo of appeal showing the names of the substituted, corrected cause title of the memo of appeal showing the names of the substituted defendant number 1 to the registry before the next date fixed. Let the this interlocutory application is accordingly disposed of. In main appeal, registry is directed to list this matter after incorporation, after substitution of the names of legal heirs of respondent number 1 in pursuant to the order dated 30/9/2024 passed in IA number 2995/2024 after Puja vacation.
I number 3036 for continuation of delay of 2626 days.
For what?
For filing application for setting aside appointment, your lordship. But there is no delay, your lordship. For knowledge of the date of your lordship, what happened in this case, your lordship, the respondent number 1.
No, whether notice will go to this applicant, heard Mr.
S. Diffusa, your lordship.
The none has appeared for respondents.
Your lordship, in earlier date, for respondent number 2, an advocate appeared, your lordship.
How many respondents are there?
3 respondents, your lordship.
Who died?
Respondent number 1, your lordship.
Okay, you take steps.
Yes, sir.
This application under section 5 of the Limitation Act, 1963 has been filed by the appellant is only sole appellant.
No, your lordship.
How many appellants?
After 7 appellant.
Filed by the appellants for condoning the delay of 2,626 days in filing the application for setting aside abatement on death of respondent number 1. Stop. Issue notice to the respondents. / opposite parties. The applicant shall take steps for issuance of notice upon the respondent / opposite parties within 7 days from the date of this order, returnable on 4th of November 2020.
All right, sir.
May I please, your lordship? Lordship, this second appeal 89 of 2015 was dismissed for non-prosecution by the order dated lordship 29 2023. Therefore, lordship, we have filed this IA 3052 of 2024 for the
Sir.
condemnations of delay of 235 days in filing the restoration petition. Therefore, lordship, the notice may be issued to the respondents, lordship.
This heard Mr.
And Brahma, lordship.
M. Brahma. N. Brahma, learned counsel for the applicant. This application under section 5 of the Limitation Act of 1963 has been filed by the applicants for condoning the delay of 352 days.
25
300 and
25 days, lordship.
you have mentioned 52.
Lordship. IA lordship 305. There might be some typographical mistakes.
It is corrected by hands and by handwriting and mentioned 353 days. 353 days in preferring an application for readmission on of RSA number 89/2015, which was dismissed for default. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by registered post with AD within 7 days from the date of this order, returnable on 8th of November 2020.
Wait, please, my lord. My lord, the IA has been filed praying for condonation delay of 1001 days. This matter is come for the first time, so we will be allowed to take steps upon all the respondents.
Heard, miss, what is your name?
Bharati.
M.
Bharati.
M. Bharati, learned counsel for the applicant. This application under section 5 of the Limitation Act 1963 has been filed by the applicant / appellant for condoning the delay of 1001 days in filing the connected MAC appeal. Stop. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 8th of November 2020.
What's your views?
Limitation Act for the person. Record form Limitation Act.
Wait,
Limitation Act.
it is in the application for condonation of delay in filing appeal, lordship. Delay of 253 days.
Heard Mr. M. Talukdar, learned counsel for the applicant. This application has been filed under proviso to section 173 of the MV Act 1988 as well as section 5 of the Limitation Act 1963 for condoning the delay of 253 days in filing the connected MAC appeal. Issue notice to the opposite parties. The applicant shall take steps for issuance of notice upon the opposite parties by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 8th of November 2020.
This I is for condonation of delay of 142 days, Lordship, in preparing this MSc appeal, Lordship.
Third, Mr. P. J. Borman, learned counsel for the applicant slash appellant. This interlocutory application has been filed under section 5 of the Limitation Act of 1963 for condoning the delay of 142 days in preferring the connected MSc appeal. Issue notice to the opposite parties. The applicant shall take steps for issuance of notice upon the opposite parties by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 11th of November 2024. List accordingly.
Lordship, in this case, I am appearing for respondent number 1, and we have not yet received the memo of appeal copy.
Third, Miss,
My lord, I am for the.
what is your name?
ST Bokt, your lordship.
SP?
ST Bokt.
You are for
I'm for the
appellant.
appellant, your lordship.
SP?
ST Bokt.
ST Bok,
Lordship.
learned counsel for the appellant. Also, Miss
S. Musahari.
S. Mushahari, learned counsel appearing for respondent number
1.
Respondent number 1. This appeal under section 173 of the MV Act has been preferred, including the judgment dated 27/2017, passed in MSc case number 128/2010 by the Motor Accident Claims Tribunal, Dhubri, whereby the claim application filed by the present appellant was dismissed. The appeal is admitted. Issue notice to the respondents. Since Ms. S. Mushahari has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. Stop. However, the appellant is directed to furnish a memo of appeal along with the annexures to the learned counsel for respondent number 1 within 2 days from the date of this order. As regards respondent number 2 and 3 are concerned, the appellant shall take steps for issuance of notice upon the said respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 6th of November. Let also the case record of MSc case number 128/2010 be called for from the delay was condoned.
Yes, your lordship.
A call for from the concerned tribunal. List this matter accordingly.
Obliged. Obliged.
In this case also, my lord, we are appearing for respondent number 1, New India, and memo of appeal, in this also, we have not yet received.
None has appeared for the appellant on call. It appears from record that this appeal is in this appeal, the appellant is represented by a legal aid counsel. Stop. Ms. S. Mushahari, appearing for respondent number 1, is present. She submits that she has not received a copy of memo of appeal stop. The appellant is directed to furnish the copy of memo of appeal to the learned counsel for the respondent number 1 within 7 days from the date of this order. This appeal has been filed by the appellant under section 173 of the Motor Vehicles Act 1988, impugning the judgment and judgment dated 18/12/2013. Whether delay has been condoned.
Yes, my lord.
2013 passed by the Motor Accident Claims Tribunal number 2, Kamrup, Guwahati, in MSC case number 2555/07, whereby the claim of the appellant was dismissed. The appeal is admitted. Call for the record of MSC case number 2555/07. Oh, no, it's not like it. Last line to continue record. Appeal is admitted to Katidigo, already admitted. It appears from the office note that the records of MSC case number 2557 public 2555/07 has already been received by the registry. It also appears that this appeal has already been admitted. Let this appeal be listed for hearing in usual course.
Most obliged. Right, please, your lordship. A lordship matter may be taken after puja vacation as my senior is hospitalized.
What is the matter?
The matter, my lord, that amendment, my lord, amendment was allowed at the time of execution. That is why, my lord, that's a belated stage, my lord. There earlier
You
there
are
is no-
challenging that.
my lord.
Amendment of the plane.
Amendment of the plan in so far the DAG number is concerned. DAG number, in place of DAG number, it was pata number, and pata number, in place of pata number, DAG number, that slight mistake. However, my lord, during the proceeding of like 18 years, my lord, no diligence has been seen, my lord. Earlier also, my lord, there is amendment plan was filed, my lord. My lord, that is why, my lord, that belated stated there is some judgment, my lord, whether the execution court can amend at this stage, and while the case is, my lord, decree is my lord confirmed by the appellate court, and thereafter whether the trial court can amend in that judgment also there. My lord, my friend is, my lord, hospitalized, my lord.
Is heard Mr. MP Sharma.
My C. Goswami, I'm C. Goswami.
No, sorry, heard Mr. C. Goswami, learned counsel for the.
Petition.
On last occasion, you were ill.
My lord, last occasion I was suffering, my lord, due to viral.
Okay, heard Mr. C. Goswami, learned counsel for the petitioner. Also heard Miss
R. Yadav.
R. Yadav, who submits that the conducting counsel, who is ill?
T. Islam.
Tawhidul Islam.
T. Islam is indisposed, and on that ground she may praise for an adjournment. Learned counsel for the petitioner does not opposes the prayer. hence the prayer is allowed. Let this matter be listed after puja vacation on a date to be fixed by registry.
Okay.
This is an appeal by the United Insurance Company. Madam. Basically, my lord, we are praying that, my lord, the pay and recovery principles of will apply. Because, my lord, the first of all, my lord, the driver of the vehicle was not made a party. And the driving license, my lord, we actually brought a, my lord, RTI reply from the, my lord, DTO Vokha.
We'll admit it. Admit it and fix it for you. Parties have appeared.
My lord, my learned friend appears. my lord.
I am appearing for respondent number 1. That
Because, my lord,
is,
the delay condonation petition was there, so notice was already issued, my lord.
Delay was condoned.
Delay was
Delay
condoned.
was condoned.
Delay was condoned. Then, my lord, we made paper publication also, my lord, for with regard to my lord, the respondent number 2, my lord. The owner of the vehicle. She has not appeared. We made a paper publication, my lord.
Why this IA?
IAS for stay of the, my lord, judgment, my lord.
Stay of?
We will deposit 50% loan.
say a lot. Subject to the condition.
In main appeal, MSC appeal 298, heard Mr. M. Datta, learned counsel for the appellant. Also heard Mr. D. Mandal, learned counsel for respondent number 1 / claimant. Who is the appellant? Right.
United India.
In United Nations. The, my lord, the respondent 1 is a claimant, my lord. And respondent number 2, it's, my lord, it's wrongly written as a driver, my lord, the memo appeal. It's, my lord, and the respondent number 2 is the owner of the
Owner
offending
of the
vehicle. She has not appeared, man. It's by the paper publication.
This appeal under section 173 of the MV Act, 1988, has been filed by the appellant / appellant insurance company, impugning the judgment and award dated 16/9/2022, passed by the Motor Accident Claims Tribunal, Nagaon, in MSC case number 284/2018. So issue notice to the respondents. Since Mr. D. Mondal has appeared for respondent number 1, only one,
Only one.
One, man.
no formal notice need to be issued to respondent number 1. However, as regards the respondent number 2 is concerned, the appellant shall take steps for issuance of notice upon respondent number 2 by registered post with AD, as well as by usual mode, returnable on 12th of November 2024. Let the case record of MSC case number
284,
what is the MSC case?
284, my lord, 18.
284/2018 be called for from the concerned tribunal, list accordingly. In IA, same counsel, lawyer secretary. This interlocutory application has been filed by the appellant applicant / insurance company, praying for stay of execution of the impugned judgment and award dated 16/9/2022, passed by in MSC case number 284/2018, which has been impugned by the present applicant in the connected appeal, which is registered as MSC appeal number 298/2024. The learned counsel for the applicant has submitted that by the impugned judgment and award, the respondent slash claimant was awarded a compensation to the tune of rupees, how much?
2,37,700.
2,37,700. Stop. Learned counsel for the applicant has also submitted that the insurance company is ready to deposit the 50% of the awarded amount in the registry as a condition for staying the execution of the impugned judgment slash award. Stop. Considering the submissions made by learned counsel for the applicant, notice to respondent number 2 in this case is waived, and this interlocutory application is allowed. Stop. The execution of impugned judgment and award is hereby stayed, subject to payment of 50% of the awarded amount by the applicant before the registry of this court within a period of
4 weeks, madam.
4 weeks from the date of this order. This interlocutory application is
Your lordship, I may be allowed to withdraw the same. Your lordship.
let them in the same.
In the same, once such deposit being made.
Stop. If such deposit is made within the stipulated time, the registry shall disburse the same to the respondent number 1 claimant after proper verification. This interlocutory application is accordingly disposed of.
Obliged, your lordship.
Highly obliged.
Item 7.
My pleasure. My lord, this appeal has been preferred by the appellant, my lord, for paying for enhancement, my lord.
Third, Mr.
A. Manu.
A. Munnaf, learned counsel for the appellant. This appeal under section 173 of the MB Act has been preferred by the claimant slash appellant for enhancement of the compensation awarded to the appellant slash claimant by the impugned judgment and award dated 31/5/2024 passed by the Motor Accident Claims Tribunal, Gwalpara in MSC case number 177/2020. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents within 7 days from the date of this order by registered post with AD as well as by usual mode. The notices are returnable on 13th of November 2024. Let also the case record of MSC case number 177/2020 be called for. Registry to take steps for requisitioning the aforesaid case record. List accordingly.
Obliged.
May I please be my lord? Lordship, this appeal is prepared by the claimant for enhancement of compensation, lordship. The appeal may kindly be admitted.
Third, Mr. A.R. Agarwala, learned counsel for the appellant. This appeal has been filed under section 173 of the MV Act by the claimant appellant, claimant/appellant, praying for enhancement of the amount of compensation awarded to him by the impugned judgment and award dated 28/6/2024, passed by the Motor Accident Claims Tribunal number 1, Kamrup Metro, in MAC case number 1414/2018, issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Let also the case record of MSC case number 1414/2018 be called for from the concerned tribunal. Registry to take steps for requisitioning the records. Let this matter be listed after 4 weeks.
Appeal admitted.
Ek line uporat dibo. This appeal is admitted.
What's the decision stated to appeal, Lordship?
Heard
The
Mr.
ground-
A.J. Sakya, learned counsel for the Appellant Insurance Company. Stop this appeal under section 173 of the Motor Vehicles Act has been preferred by the appellant, impugning the judgment and award dated
9/7/24, Lordship,
9/7/2024,
filed by MACT Kajolgaon Sirang.
passed by the Motor Accident Claims Tribunal, Kajalgaon, Sirang, in MSC within bracket death case number 24/2022. Stop. Issue notice this appeal is admitted. Stop. Issue notice to the respondents. The appellant shall take step for issuance of notice upon the respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 14th of November 2024. Let also the record of MSC within bracket death case number 24/2022 be called for from the concerned tribunal. Interim is there.
Lordship,
How much was the
award, Lordship, 3,99,700.
deposit? 50%. In interlocutory application, heard Mr. A.J. Sakya. This interlocutory application has been filed by the applicant under Order 41, Rule 5 of the Code of Civil Procedure, praying for stay of the execution of the impugned judgment and award dated 9/7/2024, passed by the Motor Accident Claims Tribunal, Sirang, Kajalgaon, in MSC within bracket death case number 24/2022. Stop. Learned counsel for the appellant applicant has submitted that the applicant insurance company is ready to deposit 50% of the awarded amount as a condition for grant of stay Stop. Considering the submissions made by learned counsel for the applicant, the issuance of notices to the opposite party is waived, and this interlocutory application is allowed. Stop. The impugned order dated. The execution of impugned judgment and award dated 9/7/2024, passed in MSC case number MSC within bracket death case number 24/2022 is hereby stayed, subject to on subject to the deposit of 50% of the awarded amount by the applicant to the registry of this court within a period of 4 weeks from the date of this order. This interlocutory application is accordingly disposed of.
Obliged.
Make please your lordship. I will say regular second appeal lordship. Last occasion, the honorable court was asked us to file the Javabandi copy or certified copy lordship. We already submitted the affidavit lordship and original copy lordship. We can undertaking to file.
Why this IA?
IA is for lordship,
Stay.
for stay of the, because we are possessing lordship, status quo may be maintained lordship till final disposal. Substantial question of law and lordship, page 11 lordship.
What is the
Substantial question of law, may I read lordship, page 11 lordship. Whether the learned trial court as well as the learned first appellate court committed perversity by dismissing the present suit of the plaintiff on the basis of earlier title suit number so and so under section 6 of the specific relief act, wherein the original plaintiff of the present suit was not made a party to the said earlier suit. Lordship.
what is the fact? What is the case?
Fact is that lordship, my grandmother lordship donate, as we inherited the property as per our inheritance lordship, because normally in Varakpally lordship or there are Javamadi is there. The learned, both the court lordship taking that view that we have no patta for which our suit was dismissed, and they filed one suit lordship. We are not the party. Court has admitted that. Court, learned court below has admitted page 40 lordship, paragraph on perusal of the case record of title suit number 6892, also cross examination DW1.
No,
It is
no, Mr. Majumdar,
lordship, please.
you tell me your story.
Lordship.
First, let me understand your case.
Actually,
You were the plaintiff.
lordship, we are the plaintiff. We filed a suit for declaration of right, title and interest of the suit property lordship.
How much is the suit property?
Suit property is nearly total, it's now very less, 4 point something. Earlier it was more. It is a joint pattal, joint
Land,
land law.
land.
And we filed, they are claiming by virtue of the title suit where I
No,
was
no,
not a
what
party.
you were the plaintiff.
I am the plaintiff.
You claim right, title and interest.
Interest lordship.
And possession was with you or
Possession was with us lordship.
confirmation of possession?
No, lordship, here in our prayer lordship.
Now, what happened to your suit? It was dismissed.
Dismissed lordship. It's a concurrent finding lordship by saying that we have only Javabandi lordship, but we have no permanent patta.
Your suit was dismissed.
Dismissed lordship.
Appeal was also dismissed.
Dismissed. We are possessing lordship till date.
Now, what is your ground where the court went wrong?
Court went wrong, your lordship, page 40. I have, since my first question, number A of substantial question of law lordship, A, which is dealt by learned court below appellate court, page 40 lordship,
Yes,
paragraph number 8 lordship.
yes.
On perusal of the case record of title suit number 68 of 92 and also cross-examination DW1, it is seen that the suit is in the present plaintiff was not a party. Section 11 of the CPC states that court has admitted lordship, we are not a party. How they can take away our property lordship?
No, read para 8.
Lordship, para 8. On perusal of the case record of titles and also cross-examination of DD, it is seen that the suit, the present plaintiff was not a party. We are not a party lordship in that suit lordship.
Thereafter,
Section 11 of the CPC state that no court shall try in the suit or issue in which the matter directly or substantially the issue has been directly or substantially in the issue
in a former suit between the same parties or between the parties under whom they or any of them claim litigating under the same title in a court of competent to try the such subsequent suitor, the suit in which such issues has been subsequently raised and has been heard and finally decided by such court. Then lordship, in the present plaintiff was not made a party. Next paragraph 9, lordship. Not made a party in the title suit. Now we are not made a party, lordship.
Yes.
As evident from the deposition of DW1, so the present suit cannot be said to be between the same parties and so not barred by the principles of res judicata.
Yes.
Lordship, the defendant number 1 other than taking the plea that the suit is barred by waiver estoppel accusations did not lead any evidence to the prove it. Hence, the suit filed by the plaintiff is not barred by res judicata, waiver or estoppel.
That is right.
Right. We are the plaintiff, lordship. It is correct, lordship. Learned court will admit it. And then next point, lordship. Paragraph 10, lordship, issue number 5. Whether the plaintiff is entitled to get the declaration of right title interest over the suit land. The plaintiff in the plaint as well as the evidence of Peter's deposed that he has a right
No,
title.
your submission is that the trial court decided the suit against you on the basis of earlier suit filed by
them.
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 Where is that observation by the trial court?
Lordship, then next point, lordship, I'm coming just that one. And paragraph 10, lordship.
Yes.
Interest over the suit land is inherited in being descended. Here is our case, lordship, of Halima Bibi, who was the owner of the suit land. PW1 exhibited the copy of the Jawanbandi of RS Patta number so and so. Exhibit 2 shows that Halima Bibi is one of the Pattadars from whom, lordship, we are inheriting the property. Other than Exhibit 2, PW have not exhibited or furnished any documents to prove the title of Halima Bibi over the suit land. It is a settled principle of that Jawanbandi is not the sole document to confer title. Moreover, the plaintiff also did not produce any documents to show that the suit land will develop upon him. We are possessing, lordship, it is a homestead land, lordship, for which we had taken a substantial question of law, lordship. Whether the learned court below committed perversity by not appreciating the Exhibit 2 Jawanbandi and the second RS so and so, where the names of the ancestors of the plaintiff is recorded and not considered by the considering the plaintiff's claim over the suit land by the right of inheritance. So my respectful submission, these questions are very much, lordship, I pray, lordship, the appeal may be admitted, let the LCR maybe call for and the other side may appear in the meantime. Till then, lordship, status quo maybe we have a miscase for that, lordship. We are inheriting the property, we are till date in possession.
You are in possession.
Possession.
Now what you apprehend?
We are paying
Have
not to evict or disturb us, lordship.
Have they tried
And as well as they are trying to enter by virtue of that decree, lordship, that where I was not a party. I have in my miscase, I have categorically stated, your lordship.
that decree, any execution has been filed?
That degree, I think.
How the execution of that case?
Not execution of that case, lordship. Our prayer is for stop from changing the nature and character of the suit land and alienating the transferring the suit land during the pendency of the instant suit.
No, you are saying suit land is in your possession.
Lordship, they will, lordship, after hearing the word, lordship. Lordship, paragraph 7 in my IA, lordship. Basically, it is necessary to grant injunction in favor of applicants and against the opposite parties by restraining them from taking possession of the scheduled land and
IA,
Lordship,
before going to IA,
Lordship,
what is the substantial question of?
Lordship.
Your appeal
Sorry,
is
sorry,
with-
Lordship.
where this first substantial question of law is not there. Because you have to show that the suit was dismissed, your suit was dismissed, whether there was a counterclaim of the
By them.
other side, no.
No,
So your suit was.
Lordship, I am on that, Lordship. These two, whether the learned fool as well as the learned first able committed perversity by dismissing the present suit of the plaintiff on the basis of earlier title suit number under 6, where the original plaintiff of the present suit was not made a party.
No, now you have to show that it was dismissed because of the earlier suit.
Lordship,
Where it is.
it was, I
In
am
in the judgment, there has to be an observation.
Lordship in the court of civil judge, I like on the Lordship.
No. My query is, Mr. Majumdar,
Lordship, please.
in title suit number 14/2010, which was filed by you.
Lordship,
In title suit 14 of 2010 was filed by you,
Lordship, we
claiming- which was dismissed.
Lordship,
It appears that it was dismissed because you failed to show any title document,
title.
but it was not dismissed because the other side case was decreed in a different suit.
Lordship,
So number one is not there.
then number 2, Lordship also. Number 2, Lordship. Ground number B, whether the learned committed perversity by not appreciating the exhibit 2 Jawamandi or second assurance of where the names of the ancestor of the plaintiffs is recorded and not considering the claim.
But in case the Jamabandi is not a document of title.
Lordship, with all respect, Lordship, normally in
No, but there are.
ancestral property, normally, Lordship, in my own paternal property, Lordship, only Jamabandi, with all fairness, out of my submission, Lordship, regarding legal point, Lordship, if anybody will ask me to show the, I can only.
But that is the law. Law says that records of right.
Lordship, I am just coming, but just I am relying.
Whether Jamabandi can be.
Lordship,
Can confer title. Or whether can it be
Lordship,
interpreted as
it
document.
was in 2003 GLT, Lordship, by our honorable, dishonorable court, Lordship, section 40 and 56, record of title. Entries in the record of right, that is Jabanbandi based on Chita, are to be founded on the basis of actual possession. Sir, raise a presumption regarding possession in favor of recorded patradar unless rebutted.
No, possession, the presumption regarding possession is always there.
Lordship,
Jamabandi can be a document from which presumption of possession may be there.
Lordship,
But your suit was dismissed not on the
That
ground
you
that you failed to prove the
What is the
title.
patra? Title, that is Patta.
Yes.
Patta. We have a Lordship. We have a Jamabandi Lordship. We exhibited the same, and the for which Lordship the honorable court actual basis of possession.
Exhibit 2 is Jamabandi only.
Lordship.
And you are claiming your right on the basis of Jamabandi.
That Jamabandi Lordship.
You cannot. Can
Lordship.
you?
We can Lordship.
No,
To
where
some
is
judgment,
where is the law?
Law Lordship. Then Lordship any other day Lordship after vacation. I shall
Okay.
try to satisfy your Lordship.
Okay, heard Mr. K.A. Majumdar.
Because
Learned-
Mr. Deka will lead me in this case, Lordship, he has some because of
Okay.
this.
Mr.
will
K.
tell-
Majumdar, learned counsel for the appellant, who prays for some time as who will lead you?
Mr. Fred Deca Lordship. Yes, P Deca. Yes. Because this, Mr.
SD.
Lordship. PS Deca Lordship, sorry.
PS Deca.
We are very close every morning and evening. What his full name? Pradeep Sen Deca Lordship.
Okay, okay. That conducting senior council in a conducting council for the appellant, Mr. P.S. Deca could not remain present today. He prays for an adjournment today. The prayer is allowed. Let this matter be listed after puja vacation on a date to be fixed by registry. Finish.
March only.